Okay, I'm going to run through the attendance roll, just the roster one more time. Just for my own purposes, really. I see that we've got almost everybody here, so just make a noise, please, when I call you. Jim Alliance.
Right here.
Thank you. Cole. Everard Campbell. Thank you. Adam Franklin. Thank you. Cesar Garcia. Here. Thank you. Jose Pablo. Yes. Thank you. Claude Hector. Thank you. Nisha Joseph. Thank you. Connor. Connor's missing. Okay. Judson Robertson. Jose Gregorio. Diego. Thank you. Christopher.
Yes.
Thank you. Elizabeth. Thank you. And Laurel.
Gloria.
Did I do that again? I'm sorry. Okay. Thank you. So, our property system in the United States comes from ancient England. And we're going to get into a little more esoteric legal stuff and hopefully drift back into the practical, because I know that's more interesting. But I want to talk about a few things that are the basis for our real estate system and some of the things that we deal with on a day-to-day basis, although it doesn't sound as practical as it could be. And we're going to start off talking about estates and land. There's different ownership interests that you can have in real estate. They're different in terms of limitations on how much you own, not in terms of quantity of size, but what your overall bundle of legal rights are. The easiest, simplest is called fee simple. Fee simple means you have the whole bundle of sticks, all of it. You own the right, you have the ownership right, the possession. No one can take it away from you, and it lasts forever. Fee simple title lasts until the end of time. It's unlimited. You can give it to anybody you want. You can do anything with it. You can give it to your heirs when you pass away. It's everything, the whole bundle of sticks. The next type of estate, which is a carve-out of that, most of the other estates are carve-outs of the fee simple or restrictions on the fee simple, is called a life estate. Life estate is pretty much exactly what it sounds like. You can give somebody ownership of property for their lifetime. This is used a lot in estate planning techniques. And the person that owns a life estate is called a life tenant. There's two ways to get a life estate. One is someone deeds it to you, which would say, to John Smith for life. Or, when someone is getting older, usually, what they want to do is they want to get it out of their estate so they don't have to go through probate, and they will deed the property away to their children, or trust or something else, and they will retain a life estate. In either case, the person with the life estate owns that property only for their lifetime. When they die, the title goes somewhere else. It doesn't have to go through probate. It's not directed by will. It goes what's called by purchase. So it's automatic in the deed. Now, in the case of a life estate that's being granted to you, I can grant a life estate to one person and grant what's called a remainder interest to the other person. The remainder interest, obviously, is what's left over. After the life estate, the person with the remainder interest owns the property. How do they get the property? The life tenant has to die. Unless, in an unusual situation, the life tenant says, I don't want it anymore, and they give it by deed to the remainder person. The life tenant has full possessory rights. That means that they can live there. They can rent it out. They can do whatever they want with the property as long as they are alive. They can actually give a mortgage on it, but the mortgage doesn't have a whole lot of value because when that person dies, poof, the estate goes away. The mortgage does not attach to any interest. The lien of the mortgage goes away. The debt might remain, because if you remember from our discussion last week, the mortgage is just a creature that follows the promissory note. The promissory note is what the evidence is, the obligation to pay. Therefore, if someone were to take a mortgage on a life estate, then the mortgage would basically evaporate because the life estate evaporates upon the death of the life tenant, but the debt remains, and the holder of the debt could file a claim if there were an estate, could sue the heirs, or they're stuck and they get nothing.
Is that common to have a mortgage on that?
Absolutely not common. The most common use of a life estate is a situation where grandma wants to get the, I'm not being sexist by the way, it's just an example. Grandma wants to get the property out of the probate estate. Now she knows she's got an estate, she's got a trust set up, she's got her house or a condo, and she doesn't want the kids to have to worry about what happens when she passes, to have to go through a court proceeding or anything else. So she deeds the property to the next generation and keeps a life estate for herself, which gives her complete control, also gives her all the obligations of paying the taxes and maintaining and everything else. The other benefit of a life estate in that situation is that it qualifies for the homestead tax exemption under Florida law, which we will talk about homestead and its various benefits when we get into the taxation issues. So the life estate will qualify for that. It is, yes?
When you say that like the grandmother deeds it to the next generation, that's considered the remainder of interest? Like the
So the way it would read would be, the deed would go from grandma to grandchild, or child, whatever, saving and reserving unto grandma a life estate. That's how the words would read, saving and reserving. The remainder interest is what is being deeded away. Now, sometimes people want to do that for estate planning purposes. Do you know what happens? Grandma's not that old. She's only 73. And she does it because that's what the estate planning people have suggested. And now she decides, I don't like living here anymore. I want to go somewhere else, but oh my God, I only have a life estate. I can't sell this property anymore. I have to go and ask the kids to let me sell the property. Well, that's something that most people don't want to be in that position. Because, you know, what happens as people get older and older, the kids start wanting to say, you know, that's really not a good idea, what you want to do. But if it's the older person's property, they really should have the freedom to do whatever they want without, I would think it to be demeaning for an older person to have to ask permission like that. So, they've come up with, and I don't even know where this originated, something called a Ladybird Deed. Now, I'm not sure where the name came from, it's not important. But the Ladybird Deed contains special language in it. It is a deed conveying a life estate and conveying the remainder to this next generation, reserving the life estate, but also reserving in the life tenant, grandma in this case, the authority to revoke it, where she can make a decision that I want to sell, mortgage, do whatever I want with the property, and I can take it back. So it's actually a conveyance. The remainder is being conveyed conditionally because grandma reserves the right to take it back.
revoke what though?
The remainder interest. She could take back the remainder interest so that she now has the whole bundle of sticks back and which she can sell. And this is a common estate planning technique because if she doesn't do it, if she doesn't revoke it, then when she passes, it automatically goes. The condition goes away because only that person has the right to exercise this right. So when she dies, it goes away. Okay?
I'm not clear on what the remainder is.
It's what's left over after. Okay, we're carving out ownership into person A while they're alive, person B when person A is not around anymore. Person B is the remainder interest.
Oh.
Okay? I give you my house after I'm dead.
And
While I'm
then,
alive, it's my house.
and then you said something about the mortgage also, so what happens to the mortgage?
Mortgage goes, if the mortgage is on, if a mortgage is on the life estate, an unusual situation,
Yeah,
it goes away. By the way, the same thing would happen to a judgment. If you got a judgment against the life tenant, and you didn't execute on it, judgment is a lien, we'll talk about liens later on, but if you got a judgment lien on the life estate, that goes away too, because the life estate goes away. There's no more, when the person dies, there's no more life estate. There is a little side, not used very much, but there is something called a life estate for the life of another. It's a, I don't remember the French, I think it's pour entre vie. Anybody can help me if you understand French, because I don't.
Is that the tie in the reverse mortgage?
No. Nothing to do with reverse mortgage. Talk about that. No. I'll be happy to answer that question. It has nothing to do with this. So it's an unusual situation. It could be, okay, I'll give it to you. You have a person with a special needs child. Or, yeah, okay, a special needs child. And you give the life estate to the grandchild for the life of the special needs child, with the intention that when the special needs person passes away, the remainder interest now goes to the 3 children and not just the one that had the life estate, because the planning technique here would be the person that is being given the life estate for the life of the special needs person, say is the one child of the special needs person who's going to live with them. So you would give that person the right to reside there with the special needs person, as long as the special needs person was alive. When the special needs person passed, then you don't want just the one child to benefit, you want all the children to benefit. That's an example of why that would be used. Unusual.
But so for the life estate, as soon as you sign the papers, then it goes to, then it's, if it's not a Ladybird deed, then they're signing their rights away to the property.
To the remainder interest.
Yeah.
And even in a Ladybird deed, you're signing it away subject to the condition that you can take it back. That you have to actively take it back. A variation that I don't have on the outline under fee simple, which you will not see anymore, but it's just historical, was something called fee tail. Tail like the tail of a dog. And this was, again, ancient England. We don't have that here in the United States. And the conveyance was to John and the heirs of his body. And I believe in ancient England it can only be to male children and grandchildren down the line. And so that you couldn't, the property was to keep the estate in the family. So that was a limited estate where you couldn't convey it out of there, and it was in fee tail. That doesn't exist here anymore. I don't even know if it exists in England. They do things differently. So those are different types of one other estate that's not really thought about as an estate well, it is an estate in land, but you don't typically think about it, is an easement estate. It's not up here. I don't have it up here. I'll talk about easements probably somewhere else, but I remembered that it's important to discuss at this point because it is technically an interest in the land. It is, an easement is the right of one person to cross over the land of another person, which is very important in many, many situations. And in fact, you will see easements in deeds, particularly commercial property, and then they become part of the ownership right of that property for, not only for ownership, but for title insurance purposes. And that can be mortgage and it goes together. Why would you need such a thing? Well, let's say the ownership that we're talking about is that seat in the corner. Okay? That's the property we're talking about. The only way he can get out of his property is to come across the back of this row, where we have other owners. Okay? If the ownership of each, and we'll take each seat as a lot for the purposes of this example. So if each lot extends from the front of this table to the front of that table, and that's the lot, in order for someone to cross over your land, you have to give them a legal right to do so. Now, if you have a platted subdivision, then there'd be streets that are owned by the public, that are dedicated to the public, and that wouldn't be a problem. But in a lot of situations, they don't exist. It could be that the people had owned this entire block, take the whole table as a block, and they decided to sell off the back piece to someone who didn't need the frontage, or maybe divide it up into different properties, warehouse buildings, little office buildings, doesn't matter what it is. So you provide a private easement that goes the length to get to a dedicated road, which would be the middle aisle here. Okay? So that easement is an actual property right that, as far as the person who holds it, it's an ownership interest. As far as the people over whose land it goes, it's actually an encumbrance on their land. And to get a little fancier, we have two estates. We have the dominant estate and the servient estate. The dominant estate is the estate that has the right to use it. They dominate the land, if you will. That person has the right to cross over. The servient estate, it's like the word servant, is the land that is crossed over. Technical. Sir.
So it's the same thing like when FP&L has an easement in your backyard for their power line.
Exactly right.
Or you can't pull your pool, like, so they have easements for that, or you have on the side of the roads. Like I worked on a project for the Village of Wellington, a GIS project, where we had to map out all the horse trail easements that were already donated before the subdivisions were plotted out.
Right.
So there's a big argument about 7 years ago between the landowners of all these horses saying, my neighbor can't go through my land with their horses. These trails where people walk their horses. So it created this big ruckus in Wellington. So Wellington had to go back and say, this easement goes through this person's yard, so your neighbor could walk your horse through your yard. And it was a big deal.
Well, when I lived in Davie, you didn't see it because it didn't physically exist, but there was actually just that, a horse easement alongside the entry driveway to the gated neighborhood. And it was ignored, but it was on the plat, which means it was part of the recorded subdivision. I'm getting a little, well, it's okay, it doesn't matter, this is in context, so it's good. A plat is a map that is created. So let's take this entire room. This entire room would be a piece of land. And a builder wants to develop houses. Again, we're going to use the example, each chair is a house lot. Each seating area is a house lot. And each table is called a block. So the map would divide the property into lots and blocks. And you've all seen this if you live in a home, if you ever looked at papers dealing with a home, this is reality. This is what's going on, is that the houses are, for the most part, land is platted. When that happens, they create maps of the streets. That gets recorded into the public records, and the streets are dedicated, which means the owner of the big piece, when he files this map, is saying that these are now no longer private property here. This is now dedicated for the use of the public, which can be used not only for ingress and egress, cars and pedestrians, bicycles and horses, but also for the utilities. That all that stuff will be on the plat. And when I get into land use, I'll try and remember to bring in a copy of a survey, post-it, copy of a survey, copy of a plat, so you can see what those lines look like. Okay, so those are the interests in land. Now I want to talk about how you can hold the interests in land. Obviously, one person, it's easy. One person owns it, it's in their own name. What about two persons? Different ways for two persons or three persons to hold property. What's that? But you're cheating because you're looking.
No, I don't.
You want to try and tell me the difference?
Sometimes I can remember. Okay, tenants in common means that both of us own it together with the same common rights.
And then?
Joint tenancy, I believe it's like right of survivorship. It's like if I own it, you own it, I die, you take the rights of it. But tenants in common means that if I die, my heirs can take their half, right? So it's still, you cannot split the share. So unless I sell over tenants in common, but tenants joint and survivorship means if I die, when we own something together, you take it over. Usually it's a wife and husband type of thing. No? Okay.
Careful.
Then
You're close, but
yeah, well,
the answer's really, really nearby.
Yeah.
Look up. You're doing really well. Look up.
The next one is tenants of entirety.
Which is?
Is the one that usually.
No, not usually. Come on. I'm gonna go back through this, but he's doing great.
Tenants of commons mean entirety means that owns the whole thing or something like that?
Nope. You so close. Okay. Really very good. Thank you. It's unusual that if you're not involved in it, in the legal side of it, you might not know these things, but that was really good. Tenants in common, you're basically partners. You each own the land. You can do what you want with the land. You can, nobody's gonna buy a half, but mind you can convey it separately. But the key there is when you pass away, it goes to your heirs according to how you direct it. All right? Joint tenants with right of survivorship, and by the way, to create it in a deed, you need all those words. Joint tenants by itself doesn't do it. Under the law, you must have the words with right of survivorship in order to create this special interest. And you have to acquire them at the same time, and they have to be equal ownership rights. It's the unities of title have to be there, and they have to be equal, like both fee simple. When one dies, winner takes all. However, either party can sever that joint tenants with right of survivorship by conveying it to somebody else. So you might agree today with your best friend that you're going to own this, and neither of you have family because you've worked together so long. If one dies, the other gets it. If you have a fight and you change your mind, one of you can convey it and break it, and then you become tenants in common. Okay?
Yeah.
Now, the third, tenants by the entireties can only be between husband and wife. A married couple. Let's change that to. It has to be between a married couple. And the legal fiction involved, it's not a legal fiction, but in the other two, each party owns a half. Tenancy by the entireties, the married couple is a unit. The unit owns the whole thing. That has a lot of special rules that go with it. Special rule number one, a judgment against one person. The judgment can become a lien if it's properly recorded and attached to your real estate. A judgment against one of the spouses will not attach to the title to the property because it's a unit. If there's a hovering judgment against one of them, if they get divorced, the tenancy by the entireties turns into tenants in common, and then that hovering judgment can attach to the one party against whom the judgment was entered. Following? Okay. Obviously, tenancy by the entireties, somebody dies, the other one owns it, and it's the whole thing.
Okay. So, great question. Tenancy, so that's why when if I obtain a mortgage and I'm married and my wife is not on the mortgage or even on the deed, but she's married to me.
That's homestead, that's different.
No, what I mean is they have her sign on the mortgage.
That's homestead, that's different.
That's okay. Because I was wondering why would they have her sign on, why would they have them sign on the mortgage?
Because the Florida, okay, homestead. Hold on. I'm jumping, it's okay, we'll get back to it when I'll answer the question, you get a preview, I'll get back to it later on. So homestead is one of those creatures, it is created by the Florida Constitution. It is there for the protection of the family. It is there, there's three things. There's the homestead tax exemption, less important. There's the exemption from forced sale, which means that a judgment cannot be executed against your homestead. And there's the descendant distribution, which means there's special rights as to who can inherit homestead under what circumstances, and it is governed by the Florida Constitution. What you're talking about is a limitation on conveyance, that a married person cannot sell or encumber the homestead except joined by their spouse. So in your circumstance, that's why, now if that was not your home that you're talking about, if you owned a piece of investment property in your own name, your wife would not have to join. Okay? Homestead's where you live. It's your residence.
Is that only for Florida?
This is Florida. Yes, this is Florida. Okay? It's the Florida Constitution. All right? There's still a dip into. So tenancy by the entirety, so they get all the things. Oh, another little quirk, and a slight exception to that conveyancing rule. So if a married person owns Homestead and wants to convey it to himself and his spouse as tenancy by the entireties, the other spouse does not have to join. Used to be, there was all kinds of crazy rules, but they fixed that by statute.
What that means? That means that if someone had owned a house before, or owned property before, now he gets married, he can now put it in joint between the two?
Yes, without the spouse joining.
That's what I meant, when I was like, because I noticed that when you close, if you're closing, I noticed several times when people are closing lately, or I've been my closing too, they always ask for the spouse to sign off. On
Residential?
Like a residential.
Residential, yes.
They're saying that even if they're not on a mortgage, they just have to
That's why.
sign off saying that they know you
50%.
purchased this property.
No, that's not why. It's not good. It is because it's Homestead.
Okay, even when you're, with the mortgage, you request it.
The
To
mortgage
acknowledge
doesn't
to say that.
Not acknowledged. Okay, so let me give it to you again.
Mhm.
Florida Constitution says that a married person joined by his or her spouse may sell or convey the homestead property. The reason is you are protecting the family. When the person owns homestead and they pass away, the spouse has rights to live there, the children have rights to the property, and so they're preventing, it goes back to 100 years ago when you were trying to protect the family from the farmer selling the family farm out from under them. It's the same thing though. The house for a lot of people is their most important asset. And it's to prevent a married person who owns the house from doing something to thwart the family and throwing the family out on the street.
That's the release of the property. That's if I'm the husband, I'm selling the property.
Or mortgaging.
Or mortgaging.
Because what happens if you mortgage, here, I'll carry you out an example. You mortgage it, and you take the money, you put it in your pocket, and you run, and you vanish.
You seen that too?
Okay, of course you have. So that's to protect the family from that, the wife has to join.
How did you word the joint tenancy with survivorship? If owner passes, the other will.
Winner take all. That's how I said it.
But you said prior to death, the owner can sever it by selling?
Yes.
But what-
Either one can sever, not necessarily selling, you can convey it to another person.
By conveyance? And then can you decide on like percentage of ownership
No. It has to be equal.
for all of them?
For joint tenants with, well, for joint tenants with right of survivorship, it has to be equal. Tenancy by the entirety it's automatically the whole. Tenancy in common, you can do anything you want.
Okay.
Tenants in common is mostly what corporations we use.
No, don't mix it up.
My question is, so let's say that the spouse dies, and the wife is the one that is a survivor.
In which,
In which category then that becomes? So for example, it will not be in the entirety, so what does that?
no, you mean,
become?
so wait, before the one died,
It was tenants by the entirety, right? So
then the surviving spouse is the sole owner.
it's a sole owner,
Yeah.
but does that become what, like? a
Nothing.
license? Nothing?
There's
Okay.
no, so those live, be simple,
Mm-hmm. Office, okay.
be simple. Everybody confused? It's a little technical, but it's because what happens is, you'd be surprised, you go to a closing, and in South Florida, we have, as you probably know, lots of second families,
Yes.
lots of them.
And
And
I get this.
sometimes you've got somebody that's got lots of money, and you have the new spouse that doesn't have so much money. And what you do here at the closing can make a huge difference, because I had one particular situation I know of where they had a prenuptial agreement. The man had lots of money, the woman had much less money. They had a prenuptial agreement because it was like his third or fourth marriage. And, well, it happens. You know, you get older, and it happens. Actually, it was probably for both of them, but still. So he was very careful to have the prenuptial agreement done, thinking he was protecting them. So he was buying a house for them to live in. And we get to the point of buying the house, and of course I asked the question, how do you want to own title to this house? And I said, do you want it in both names? And they look at each other, and I don't know exactly who suggested what or who nodded or who went along with it, but they said yes. So it wound up that the house was in both names. Well, 8 years later, when love flew out the window, and they got divorced, she owned half the house. That was completely contrary to what his intention was under the prenuptial agreement, where he was trying to protect himself from that, and he wound up buying her out for $250,000. And if I remember the story correctly, she was the only one that ever got anything at the end of the divorce because of just this one little thing at the closing table that both names were on the deed.
Well, now I know the next one.
She would have gotten that anyway.
No, sir. No.
In divorce?
No. I said the prenuptial agreement. No, nothing.
There was that thing on TV which said it is cheaper to keep her.
That is actually very true.
Is there any time frame
A judge said that.
for the rights?
One of them judges on TV.
Say like, today's part?
No,
Never.
no. They don't expire till the person expires. Okay, now, I stopped you asking a question about something. Because you said you wanted to know, you used the word corporations. Well, you did ask that question, but here's the differential. All of those things that we were talking about, all those estates and land we were talking about really dealt with individuals for the most part, okay? Entities cannot have survivorship rights. Entities are not married to each other, and therefore they cannot have tenancy by the entireties. Entities don't have a life, and therefore they can't have a life estate. Although I guess theoretically, you could convey to grandma for life and remainder to XYZ Corporation. That you could have. But all that is the corporation owning it after grandma passes. Fee simple, yes. Fee simple is how an entity would probably own title. So now we're going to talk about the entities. Now we're going to talk about different ways to own real estate. Okay? When own real estate or do business. And the first is a corporation. Corporations have been around for a long time. A corporation is a person, legally. Not a human, but a legal person. That was an old case. I want to say it was Dartmouth College, but I'm not sure. So you're not held to that. That's over the next building. A corporation is deemed to be a person. However, if you have a corporate book with you, this corporation is a whole book that's got the stock certificates and the corporate seal and all the corporate records, and that's in the car with you, that does not let you go in the carpool lane. People try it. So a corporation is a legal entity. It's formed by filing articles of incorporation with the state. Corporation has officers, president, vice president, corporate secretary. You can go on beyond that, have vice presidents and assistant secretaries and treasurers.
And managers and stuff?
No.
That's only
That's
the LLC?
next category.
Okay.
There are different kinds of corporations for income tax purposes. A C corporation is a taxable entity in and of itself. The big corporations are C corporations, and they have shareholders, and the shareholders only pay tax to the extent the big corporations pay dividends to them. S corporations are pass-throughs. They are small business corporations with restrictions, like I think it's still 35 or fewer shareholders. The shareholders have to be individuals or a qualified subchapter S trust or a qualified subchapter S holding company. There's restrictions on who can own it. And with S corporations, your tax loss pass-throughs are limited, unlike other entities. So corporations were really the main, very important. Corporations have limited liability for the owners. That's the biggest issue, and which really does apply to all the entities if they're done properly. But That was the number one thing about a corporation. So you have a piece of investment property where you're going to have tenants and customers and things walking around, or you're going to have heavy machinery going around, and you don't want to get sued as the owner of this property. So the property is now owned by XYZ Corporation, and if something happens, all that the plaintiff can do is sue XYZ Corporation. The shareholders are insulated from liability. The officers, just for the reason of being officers, are not held responsible. Unless the human does something personally wrong, it could commit an act that would expose them to liability. But the officers of a corporation don't have liability just for being officers. The problem with the corporations, even the S corporations, was that there were these limitations on who could be owners. So when you got into the more complicated deals, it got a little sticky because you couldn't have other corporations owning, you couldn't have other artificial entities owning and still have the tax benefits of an S corp. So along came the limited liability company. The limited liability companies have been around for a long time also, but they were not being used in Florida because for a while there was a tax issue. There was a corporate income tax, and they were being taxed as corporate entities. Now, that's changed, and Florida has changed law. A limited liability company with the right election can be taxed as a partnership for federal tax purposes. You still have limited liability, like you do in a corporation, but you don't have the restrictions on who can own it. You can have, in either way, you can have multiple owners, you can have a single owner. There's a slight quirk, and I think I talked about this a little bit when we talked about tax-deferred exchanges. If you have a single-member limited liability company, which means only one owner, it is disregarded for federal tax purposes, which means as far as federal taxes go, that the human that owns the single-member LLC is the taxpayer, and there's no separate tax return in the middle for the LLC. You still get your liability protection from outward liability, but there's a quirk, a liability quirk when it comes to single member versus dual member, and that is where somebody is coming and making a claim against the owners individually, as not against the company. So, if two people own a limited liability company with an income flow, they have rental property, whatever it is, and one of those people gets into trouble, doesn't pay a loan, doesn't pay a credit card, gets sued for whatever reason, and a judgment is entered against that person. In that circumstance, the creditor can go after the income stream belonging to that person that comes out of the limited liability company, but they can't take the company itself or the company's asset. Question?
Yeah, I mean, is there a way to, even with an LLC, there's still ways to kind of shield yourself, even if it's a single member LLC, right?
You're shielding yourself from liability against the
company.
LLC.
Yeah,
what I'm talking about now is liability against the owner unrelated to the business of the LLC. And I'll tell you, because if you own an LLC, you and I own an LLC together, okay? And I'm off doing something bad and I incur obligations that I don't pay and I get sued, okay? They're looking for my assets to satisfy a judgment. One of my assets is my ownership with you in that LLC. They can make a claim on what I'm allowed, what comes out to me, but they can't take the LLC away from it's half yours. However, if it's a single member LLC in Florida, this is Florida, it's a single member LLC, and it's only mine, and a judgment is entered against me, one of my assets is that ownership of that single member LLC, and they can take that, which means they take my membership interest, which means they own the LLC.
Really?
Yeah.
You have a partner. What you do is, a lot of people will do
You
this.
have like a partnership with another LLC?
No, you have a second member. You have a cousin, a brother-in-law, or something that you trust, and you give them a 1% interest.
So disregarded means that you're
You're being
That's
taxed.
taxes.
They're taxing you.
Can you explain disregarded again?
Yes.
if you're a single member LLC?
Normally, let's say a two-member LLC, for example. A two-member LLC is a partnership. So it files a tax return. It owns XYZ building, it has income, it pays expenses, it has net income, it files a tax return. It doesn't pay taxes because it files a Schedule K, which pushes the income down to the partners in the proportions of their ownership. Okay? Following that?
Yeah.
It has to file a tax return, it's a tax-paying entity in and of itself, but the income flows through. If it's only one person, that's kind of a waste of paperwork, because it's all going to the same place. So you eliminate that middle sandwich, and the income just flows right through onto the one member's tax return. And it's disregarded. It's not a taxable entity by itself.
But I mean, I've done things where like I created an LLC, but like I would go ahead and file a form where I selected to be taxed as a S corp. I mean,
Okay.
Would that
That's what it is.
That's a little different.
That's the,
that's different, but I mean, does that still provide me the protection against like?
Yes. So here's the distinction. When you're focused, we have two topics going on here. One is federal income taxation. The other is corporate protection.
Okay.
That's like
Okay.
having your CPA and your lawyer in the same room.
That's a
Yeah,
bad
for
thing.
them to-
No,
yeah.
that's a very important thing because I can't tell you, I had this one client that I would do transactions and it'd be complicated. At the end of the day, the CPA, I'd get the CPA involved afterwards and I'd hear him go, "You did what?" Yeah, well, you know. Well, because there's other rules. It's complicated. Now, the big benefit of the limited liability company, besides the things we're talking about, yes, it has the same liability protection, the dome, if you will, as a corporation, but there's no restrictions on who can own it. You can have 3 other LLCs own it. You can have non-U.S. taxpayers own it. You can have corporations own it. As many ownership entities in any whatever kind you want can be members of the LLC.
So are you saying that I could create an LLC to own another LLC?
Yes, sir. Done all the time.
And then you can have a land trust own the LLC that owns the LLC, correct?
You're jumping. You're two steps away. We'll talk about land trusts in a minute. And that wouldn't be a land trust.
Okay, so I mentioned a few minutes ago, so you can't be a partner with an LLC. So you have an LLC that's owned by you and an LLC. No?
Yeah, you absolutely can.
Oh, okay.
You would be a member, though. You would be a member of the LLC, and the other LLC would be a member of the LLC.
Okay. Okay.
And now, well, you have 2 choices. You have many choices, actually. An LLC can be member managed or manager managed. Member managed just means that the members themselves are the authorized people who are doing it. However, whatever you choose, you're going to file with Tallahassee with the Division of Corporations. If you're manager managed, even though you are the member and the manager, or you may be a member and a manager, it's going to say manager on your corporate records in Tallahassee, and that doesn't necessarily reflect who the owners are. When it says members, you know that's the owners. So people will choose to be manager managed and designate themselves as managers as opposed to authorized member for privacy purposes. You can also, under the statute, give yourself basically whatever titles you want. There may be a list, but typically you could be the managing director, you could be the president, you could be the chairperson, you could be the head honcho. There's a whole list of names that you can do to show that you are the person with the authority to bind the LLC. Sir?
Well, I'll ask you over the break.
Okay, so let's talk about these. Oh, next is limited partnership. Limited partnerships are great investment vehicles where you have people who want to be involved with dollars, but not involved in management. And it's typically done as a situation where you have a sponsor or promoter who's got a project and they're trying to raise capital. That would be the general partner. General partner could be a corporation, it could be a limited liability company, but the general partner has unlimited liability. That's why it would usually be an entity. The limited partners have, I won't take a guess, limited liability. That's a tough one, right? Thank you. It's limited liability, but there's bless you, but there's rules that go with it.
What were they called?
Limited partners.
Limited partners.
Thus the name limited partnership. The limited partners have, the extent of their liability is limited to their investment in the property, or if they are guarantors of a loan, which usually they don't want to be, which is depending upon the nature of what it is and how big and so on. They in your typical, I hate to use the expression big deal, but in a typical big deal, the limited partners are in there just putting up the money and they're not signing anything. The general partners, who are the sponsors of the deal, they're the ones that are actually signing the guarantees if required by the bank. The limited partners, in order to keep their limited liability, cannot participate in the management of the property. They are kind of silent partners. With the exception of, there's usually a provision in a limited partnership agreement for major decisions. Same thing in I should bounce back to that on the LLC. It does apply to the LLC as well, but the LLC, the members can have decision-making, depends on what's in the agreement. An LLC, it's optional. Limited partnership always is going to have a partnership agreement. There's an agreement between the general partners and the limited partners setting forth the business deal, the rights and obligations, and most important, if you haven't heard this in finance, something called the waterfall. And that you're going to find in any deal document. So in the limited liability company, it's either called an operating agreement, which is what's common, or the statute also calls them regulations. It is an agreement among the members of the limited liability company, very much like a partnership agreement. It appoints the manager and it establishes what the manager's rights and obligations are. For example, some situations, a little more rare, the manager is given total control. He can do whatever he wants, including selling and mortgaging. That's a little unusual, but it does happen once in a while. More commonly, the manager is given the rights to day-to-day business operations. However, a mortgaging of the property owned by the LLC or an outright sale has to be approved by either a majority or all of the members for their protection, so that the manager just can't go and do whatever he wants. With a limited partnership, you have the general partner. Pretty much in the same situation for the most part. It could be a little unusual, but it could be that you need a vote of X percentage of the limited partners to sell, or the general partner says, look, you're coming in, you trust my knowledge, my judgment, this is my business, I'm just giving you an opportunity to participate. If I want to sell it, I'm going to sell it. And by the way, a general partner can also have limited partnership ownership interests. They're separate.
So you can be a general manager and a limited partner?
General partner and limited partner. I'm sorry, I am bouncing back and forth between the partnership and the LLC, because they're very similar, but different. In doing transactions, so in doing transactions involving any of these entities, you have to make sure that whether you're closing a loan transaction or a purchase transaction, and you have one of these artificial entities coming to you as either the borrower or the seller, you have to confirm what their authority is. Which means you need to see the operating agreement, you need to see the limited partnership agreement, you need to ask if there's a shareholders agreement in the corporation to see if there's restrictions. Unless you're going to get 100% signatures. Unless you're going to get a representation that these are all the shareholders or all the members or all the limited partners and they're all signing. Because if you've got unanimous approval, then you don't really have to worry. Otherwise, you need to make sure if the manager comes and says, oh yeah, I have authority, then you need to have some proof of that. And the easiest way to get proof in pretty much all three of them, they might have different titles on the documents, is a resolution. And the resolution is signed by either the members, the shareholders. In a corporation, theoretically, it can be signed by the directors, because the board of directors controls the corporation. Except that there is a separate rule: if you're selling all or substantially all the assets of the corporation, then you need shareholder approval. And then you have to look at the bylaws to see, do you need unanimous approval? Or bylaws being another corporate organizational document, do you need 100% approval? Do you need majority approval? Do you need 2/3 approval? What's required under the governing documents of the corporation? Because there are situations, and we had them, a closed one just last year, where it was a family corporation, and there was the one sibling that didn't agree with anything. She was just being difficult for no reason whatsoever, but they got 75% vote, they were able to sell the property. Which turned out for everybody's benefit, because anytime you have family fights, or any fights among business partners over property, it's easier to fight over the money than the property. And fights tend to result in the property not being managed properly. Who jumped into land trusts? Somebody popped a land trust. Okay. A land trust owns land. It's not just a trust that owns a piece of the entity. That's just a trust. A land trust, which you don't see much anymore, used to be used a lot for privacy purposes. Where, I think it was City National Bank was the biggest in the 70s and 80s. You would see real estate titled in City National Bank as trustee under land trust number, and there was a bunch of numbers, whatever their account numbers were. And so you have an entity acting as trustee, or a person acting as trustee, that owns the property under a trust agreement, which is not the same as the way a regular estate planning trust is set up. It's set up in a way that the only thing the trustee is going to do is whatever the beneficiaries direct them to do. They're going to hold title to the real estate, they're going to collect the rents, maybe, or maybe they're going to have somebody else collecting the rents, and they're only going to do what they're told by the beneficiaries. It's basically a way to hold title so nobody sees who's owning it. That's the main purpose of a land trust. Any trust can be a land trust with the right powers put into it, but typically a person can hold title in their trust and put the land trust, certain land trust powers in the deed, so you don't have to look at the whole trust agreement. But a typical land trust, a classic land trust, was just a title holding vehicle, mostly for privacy purposes. The trustee would own only legal title, not equitable title. Equitable title stayed with the beneficiaries. Regular trusts are property held in the name of one person for the benefit of the other. Different types of trusts. A person passes away, they want to leave money to their grandchildren. The grandchildren are underage. If you're under 21, which means they can't own stock. They can own some property at 18, but the stock is still 21. They can't enter into a contract, and they certainly don't have the ability to manage their own money. So, in somebody's will, or while they're alive, they create a trust, and they give title to the property to the next generation, say a child, an adult child, for the benefit of the grandchildren. That can be created by will or by a separate trust agreement called an inter vivos trust. Inter vivos being during life. The same document, the same conditions can be created in a will. That's a testamentary trust. Or you can create your own trust. You can create a trust while you're alive and take your property and put it into title where you are both the trustee and the beneficiary. The person that creates the trust is called the settlor, the person that sells the trust. Bless you. The trustee holds the title to the property. The beneficiary is entitled to the proceeds of the trust. Now, you could have two kinds of beneficiaries. Just like a life estate and remainder person, the trust has an income beneficiary and another beneficiary. Typically in the estate planning trusts, what happens is the older person creates a trust, and they are the income beneficiary, which means during their lifetime, it's still theirs. It was their money to begin with. But when they pass, it doesn't have to go through a court proceeding called probate. It automatically will pass. The trust will then get handed to the next person. There'll be a successor trustee, and the ultimate beneficiary gets the property. It's all by contract. You can do whatever you want inside of the trust agreement. There is a certificate of trust that can get recorded to set forth who the trustees are, what the powers of the trustees are, to prevent having to record the trust agreement or too much evidence about it that you don't want the public records because it's a privacy issue. Estates.
Quick question. I notice a lot of people put their properties into trust for
Yes.
whatever reasons. Now, I always thought when they put it in trust, was they're alive, they have a lot of money. Like personally, I know one of my investors does this, and I never meant to ask him, but he was saying it's something to protect them against anything, like any major lawsuit or any crumbling thing.
Doesn't work.
Doesn't protect.
You can't. So basically,
So what's the purpose?
the main purpose is twofold. One, while you're alive, if you become incapacitated, you're 86 years old, and you start to lose your mental capacity one way or another.
What I'm saying, he doesn't put them in a trust like his name. He puts them in a trust like his kids' names. Most of his properties, most of everything's in his kids' names or.
Good luck. What happens if he wants it back? Putting property into a trust is a gift.
Well,
Let me answer the purpose question, then I'll come back to you for a second, okay? Why would you put it into trust, okay? Why would I put my assets into a trust? It's still my assets, I'm the trustee, I get all the money, okay? Two things. I'm 87 years old and I'm losing my marbles. So I'm losing the ability to conduct my business affairs. My family, I don't want my family to have to go to court and have a judge appoint a guardian to take over my assets. Under the trust agreement, it says, if my doctor says I'm no longer mentally capable of managing my money, then my kids will take over. And it says so right there that the kids become the trustee, still for my benefit. So they start to apply the assets for my benefit, but they become the management of the trust. When I pass, rather than going through a probate proceeding in the courts, they automatically get the money in the trust just becomes theirs. So those are the two reasons. Your situation, you're actually, so when you put the money into the trust, it could be a revocable trust, or it could be an irrevocable trust. Revocable trust, you can take it back. An irrevocable trust is a completed gift. It gets it out of your name completely, which is good for certain purposes, but it's bad for one purpose. You can't take it back.
he's not trying to take it back.
Whoa, hold on.
Okay, what if that trust was being used for investment purposes and they sued the trust because something happened in there? Can they go after the personal assets?
You can't really sue the trust.
So who would you sue then?
Well, who did what?
Okay, so let's say that when somebody slipped and fell on the property.
So I own the building, all right? One is a tort. What you're talking about is what's called a tort, where I did something wrong, I'm negligent, I didn't take the ice off of the sidewalk. So
Yeah, but what if you didn't do anything wrong? They're just suing you because something happened in the property.
What happened? Somebody didn't do something for something to happen.
I mean,
When something happens, quote unquote, it's because somebody was negligent. If it's an accident and somebody's not watching where they're going and they trip over their own 2 feet, the property owner has no responsibility. If somebody's walking and the property owner didn't fill the hole in, then it's the property owner's responsibility. When you create your own trust, a grantor trust, you cannot shield your assets from that liability, because you have the right to take the money back out at any time. So it doesn't protect you from that. It's when you create a trust and make a gift to get rid of it, that the assets are now in somebody else's name.
And that becomes not somebody else's
Property.
property.
Right. You've given it to the kids. You're done. It's out of your estate.
And the reason I'm saying this is because he had some legal problems with DOJ.
Sorry. Didn't mean to-
Okay, understand something. We all have these special case stories, right? And sometimes they're great and they really help the discussion, but sometimes they're so narrow that you can't, I mean, I can't take you down every little avenue.
Isn't it a tort also like if a dog chases someone onto your property and then bites someone on your property, then you can get sued for that technically? No.
Only if it's your dog.
Okay.
If it's not your dog, you have no control over
So
that.
then, like, what is liability insurance for essentially? Like for liability renters insurance, like if
So-
someone slips and falls, it's not really
On your property.
It's not your fault.
Why not?
How is it? How am I negligent if someone slips and falls in their own
Well,
house?
because your rug was slippery.
Someone got.
Or you,
okay.
or you, oh, wait a minute. Or you put a, no, seriously. You put a throw rug down on the linoleum floor or on the tile, and you didn't put a liner under it, and you knew that every time you walked across that floor, that rug moved a little bit. But you didn't bother to tell your guests. And they came in, and they walked out and went, boom, and hit their head on the terrazzo. Now, that's your fault. That's your rug that you put down there knowing it was slippery. Okay? That's where the liability comes in.
And then
Now, if I'm a klutz and I just trip over my own 2 feet, no, that's not your problem. That's my
someone
problem.
could say that I slipped because of whatever reason.
That's why there are lawyers who have their names on the side of the buses.
So, but as far as liability and using a trust, would the best way to go about that would be to have LLCs that you're using for whatever you have a business owning assets, and then it's owned by a holding LLC, and then the holding LLC is now owned by a trust. So is that like a
Way too deep. I mean, that's a whole other set of discussions.
Because there would be a mobile property, but you want to protect yourself and have a holding company, but also you want to remain.
That'll be $5,000, please. You got a whole stack like this to go home with paper.
I was gonna say, it wasn't even an hour, that was like 5 minutes, $5,000.
No, we got to prepare the documents.
Oh, okay.
I had a friend that, she had a party and someone walked into her sliding glass door and they tried to sue. Would that be?
That's why people have their names. That's why the lawyers have their names on the side of the bus. Now, let me say this to you.
Sprinted.
If she was doing a Windex commercial, and the sliding glass doors were so invisible, and in such a peculiar... So, okay, I'll give you an example. If the sliding glass door was over there, where you would expect to find a sliding glass door, all right? And the person that had walked into them just wasn't paying attention or had consumed adult beverages to the extent that they cannot see this far in front of their nose, your friend is not going to have any responsibility. If, however, the property brothers told them that the newest trend was to have sliding glass doors in the middle of the living room because they're really cool there, and no one would have expected them to be there, and they were the cleanest, frameless sliding glass doors you could have, and you walked into it because they weren't where no one would expect, yes, you might have an obligation to put a sticker on there that said, sliding glass doors, watch out, or something. Okay? Next, estates. Oh, let me jump to the last thing real first, and then I'll come back to estates. Once upon a time, and very, very rarely done, but once upon a time, clients trying to maintain privacy would come to the lawyer and say, go buy this property in your name for me. And I would go buy the property, David Wiseman, as trustee. That's all it said. Now, between me and the client, it happened all the time. Between me and the client, we had an agreement. Between me and the rest of the world, they didn't know there was an agreement. It looks like maybe, okay, you should ask a question. But under Florida statute 689.07, if that's all you see, that vests title in me. The words have no meaning, but it's just like that. Absent knowledge of a specific trust agreement. If I was going to take title for your trust, for your benefit, then I would be my name as trustee for your name, under your land trust, for your group, whatever it was, it would be a named trust. You know, as trustee under trust agreement dated January 24th, 2020, with a name.
So by accident, you'd be conveying title to the trustee if you did it the first way?
Yes, but not so much by accident, but so if there's an agreement between the beneficiaries and that person taking the title, then you're okay. All right? If there's an express agreement. If title vests in a trustee and the trustee also has an interest, then a conveyance out has to come out individually and as trustee, which is typically how most, especially with residential property, and things where there could possibly be homestead, with all these estate planning trusts, the title companies are going to require to come out individually and as trustee, and if it is homestead, they're going to ask for spousal joiner as well.
So what should we put under notes for that? How do I like sum that up?
Next building on the law school. Okay, give me a better question.
Like, the statute, it essentially states that a trustee is vested title if it doesn't name.
Absent a named trust, if all it says is as trustee, title vests in the trustee individually. That's the sentence you're looking for.
Quick question.
Yes?
If I go look up a piece of property and I see it in John Brown's name, I know it is owned by John Brown. But when it says as trustee, wouldn't the title show who the trust or who the owner is?
What you just said to me is all it says is John Brown, comma, as trustee?
Yeah.
That's all you're going to see. Now, it might make you ask a question of the person. And the question is, Mr. Brown, is there a trustee? Is there a trust? We want to see a trust, or we want you to convey to me individually and as trustee, and an affidavit that there is no trust. You want to cover yourself. You're not going to see anything else. A trust is not public record.
And if there is, then you also, who is the beneficiary? Right?
No. No. What you can ask for is a redacted copy of the trust. Everybody know what redacted is? So you cross out the personal stuff, the names and numbers, to show that the trustee has the authority to convey the property. That's really all you're entitled to know. That the trust exists, and it has not been revoked, that they have authority to convey. And there's something called a certificate of trust that establishes those things.
So the trustee would have power to encumber the trust via
to encumber the property.
Stuff like that.
To encumber the property.
Encumber the property.
Assuming that there was no other restriction in the trust. But if you were the guy wanting to take the mortgage or buy the property, you'd want to make absolutely sure of that statement. And you'd ask him for other documentation to prove it.
So he'd have to prove that he is the actual person untitled, not just as trustee.
Correct. And I will tell you, we have situations come up all the time where title is in Mary Smith as trustee of the Mary Smith Trust dated August 17th, 1993. Okay? We get to the closing. Mrs. Smith, can we please have a copy of your trust? Oh, I can't find a copy of my trust. I haven't seen that in 25 years. I don't know. Now what do? Well, you go and you ask Mrs. Smith to sign an affidavit that she was the sole beneficiary and sole person under the trust. And you try and do as much as you can to show that there's nobody else that needs to come to the table with her.
And the title company would accept that?
Yeah. They don't have a choice. Otherwise, what you really would have to do would be to go to court and establish, which is impossible, because if she really doesn't have a copy, and it's been 25, 30 years since anybody's seen a trust, you don't know if a trust exists. Maybe she revoked it. Maybe, somebody did an estate planning trust for her and she just forgot about it.
And you have to find something recorded.
It's not recorded. It is not. It's not recorded. That's the problem. You don't record things. Now, what you do put in is in the deed into the trust, you put trust powers, and the trust powers say, and you don't have to write this down. I can either give you an example of it, or I'll post something, but basically the trust powers say when the deed goes to Mary Smith as trustee of the 1993 trust, you add the words, with full power to manage, convey, encumber, and otherwise deal with the property. And what you're doing there is you're taking an excerpt out of both the statute, which happens to be the land trust statute, to get back to that, and out of the trust itself to show on the deed that the trustee has the power to act. So in that case, you can rely on the deed coming out of the person, as long as you get an affidavit that the trust wasn't revoked and that there's no other person that has the authority. And sometimes it's just so much you can find out and so much you can get. Okay? All right. An estate. Anybody know how you get to be in an estate?
You die without a will.
Well, you're half right.
That's
Estate plannings?
An estate is it's the ownership. What happens when a person dies? You can have it with a will or without a will. An estate is different than a trust because it happens at a very high cost there. You can die. So really, what it is, there's an estate proceeding in the courts that determines who gets the property of the person who passed away. Now, here comes a very important legal principle. Title to property passes on death. One more time. Title to property passes on death. You can't have no ownership. So what happens is, the reason you have to have an estate proceeding is, number one, to determine, authenticate the documents if there is a will. Number two, to establish who gets the property, whether it's under a will or under the Florida statutes. And number three, to give somebody called a personal representative the authority to act on behalf of the decedent's estate. So it's a court proceeding. You go to court, you file the will. There's wills can be signed in a way that they're called self-proved, where it's properly witnessed, or you have to bring a witness to court to prove that they were validly executed, getting into the formalities of a will. And then the court admits the will into probate. Probate is the name of the proceeding, the court proceeding. They appoint what's called a personal representative, who's the person that acts on behalf of the estate. And then the personal representative can act as the decedent would have on behalf of and for the benefit of the people entitled to the property, the beneficiaries. Just like a trust has beneficiaries, the estate has beneficiaries. In fact, the purpose of the trust, of having the inter virtuos trust, is so you don't have to go through the court proceeding. The other thing that takes place in an estate proceeding is you publish a notice to creditors, which gives, when you publish that notice, it gives them a limited amount of time to come forward and say, we have a claim against this decedent and we want to get paid. And if they don't come forward within a certain amount of time, 60 days after publication, their claims are barred in the estate. Now, there's an obligation on the personal representative to send actual notice to known creditors. So when a person dies and you have their wallet and you see the American Express card and 2 Visa cards in there, you know you have to send a notice to those 3 companies that that person is dead. If the person has a mortgage, you have to send notice there. If there's anybody that you know might have an interest or might have a claim, you have to send them notice. And to everybody else, it's a publication in the newspaper. A notice to creditors.
Sorry, can you repeat it a third time? Title to property, what happened when he died? Sorry.
Title vests on death. The instant the person passes. Now, the other purpose of the estate proceeding and the admission of these documents and the court orders and such is to provide record evidence of that. So even though it passes, the general public's not going to know where it passed. But as of the date of death, it vests in the beneficiaries, subject to divestment. What does that mean? That means that, except with respect to Homestead, if somebody dies, property vests in the beneficiary, and now there's 12 creditors that have claims against the estate that vastly exceed the amount of that piece of property, that's the only asset, they can force that to be sold to pay the creditors, also to pay the expenses of administration. And in that situation, the person represented has the power to divest the beneficiary. So even though title vested at death, they can take it back. Kind of like with the Ladybird Deed, where they have the right to revoke it, it's vested but can be pulled away.
I thought Homestead protects you from that.
I said this except for Homestead.
Okay.
Homestead is not subject to the claims of creditors, and technically, it is not a probate asset. It automatically passes on death outside of the probate estate. However, there are circumstances where without having the state proceeding, you can't automatically determine who gets it. Because there's divisible homestead and non-divisible homestead, and I think we're going to hold off on that a little bit. I don't think I have time for that today. Well, I probably have time for it, I'm not set up for it. Because that's very complicated.
What is the entity of the estate? Like,
It's the estate.
well, like, what is that? Like, it's the
Well,
ownership of the...
it's just a name for the assets of the decedent.
Okay, that's what it is. It's like the collective
It's
asset.
like a bundle. It's like a bundle. So the person's dead, but the assets exist. They're not just floating there. Where do they come from? They are the assets of that decedent, and that's called the estate. Until it's distributed, the estate is opened. The probate proceeding is opened. You file an inventory. You file a petition as to who's going to get, who the heirs are. Why you have it's a whole legal proceeding. It's a court proceeding. Sometimes it's contested. Again, we'll get back to the second families. Oh, well, there's what we have in South Florida. I don't swear, but I'm using for an example. There's a phenomenon called a nurse for a purse. A nurse for a purse. When you see the 80-year-old gentleman going to the restaurant or to the theater with his 40-year-old friend, she's not necessarily madly in love. She really loves the Bentley he drives her there in. And he's very happy because he knows that she's going to help him get the medicines out of the cabinet, and she's going to be with him as a companion. And if he's not feeling well, she's there. A nurse for a purse. Okay? And so what happens is, when he passes away at the age of 86, and she's all of 46, his children, who are 60, object a little bit. Especially when 3 weeks earlier, she took him out for the day, and they went to a lawyer who changed his trust. And you know what? It's funny. He had another lawyer that he'd been using for years for all his very sophisticated estate planning, and that's not where they went. They went to this other lawyer that was, she went to high school with him. Okay? I'm not making it up. It happens. So, why did I tell this semi-amusing and semi-sad story? Because in the estate proceeding, when she goes to probate and to file the new papers, the kids come forward and go, wait a minute. The last 6 wills Grandpa did said that we, the family, were the beneficiaries. 3 weeks ago, Hussy took him to her buddy and changed everything, and now she's getting a big chunk of money and we're cut out. That's called undue influence. That's exactly what it is. I mean, that's really what it is. Again, it's a little far from real estate law, but that is what the legal principle is. Undue influence. She's using her youthful charms and her wiliness to take him and get him to change his will differently than the natural objects of his affection. Buzzwords. Sir.
There's another one that protects the wife. Let's say take that same, it's called a different share. Is that what it is?
Yes.
Right? So that the wife gets
That's-
10%.
Okay, but that's now you're assuming that the wife was still in the picture.
Yes. And the
But-
guy
but-
finally went with this other girl. And
That's possible too. I mean, sometimes it happens, and also not uncommon. The couple separates. They could be 65, they could be 70, and they're just sick of looking at each other. but it's cheaper to keep her. So, also, there's other benefits. She'll still get health benefits from him, Social Security benefits from him, and after all, she's the mother of their children, so he doesn't really want to screw her, he wants to screw the 46-year-old. Okay? So they live separately, but they remain married. That's another unusual thing. Folks, I'm not making this up. This goes on all the time, and it's gone on for years, because what happens is they don't want to live together, but financially and practically and all, they want to, they're staying married for business reasons, if you will, and it's cheaper. Now, I happen to have clients right now, they were married, they have children, they got divorced, they got remarried, each of them, they got re-divorced from the other spouses, and now they're hanging out again. I mean, every time I've talked to them, in their early 70s, every time I've talked to them, they're together. They own property together. I don't know. It's conceivable they could get married to each other again. You never know. Stranger things have happened. So they took a break for 20 years. You'd be surprised. There are stories like that all over, and that's what makes this estate stuff just crazy.
Professor, another question. Another term that I learned is cheat. Is that what it is? Is cheat?
It's cheat. Okay.
Which is the reversal right of the property back to the state if the person dies and doesn't have any
Nobody.
rights, right?
You've got to go pretty far. So before that happens, there's stories for everything. It's great. You're doing this long enough, you find stories that go with all this nonsense. An escheat is literally when a person has no heirs whatsoever. Nobody to take the property, and then it will go to the state. Before that happens, what will happen is you'll do some really serious searching. There are firms, there are genealogical search firms, and of course today with the internet and, I don't know, about 23andMe and stuff like that, but you'd be surprised, because if you look at the intestate statute, and again, I'm going to talk about that in another unit, but you'll see where things go and what happens and collateral heirs, and you know, your grandfather could have a brother, and your grandfather's brother has kids and grandchildren. You may or may not know them. They're cousins of whatever degree. But theoretically, if you passed away and you didn't have kids, and you didn't have siblings, and you didn't have parents, it could go up and go over to that next branch. The story I wanted to tell was, we were hired, and I don't even know how we got into the matter. Man passed away, lived by himself, to our knowledge, no family. We hired a search firm, we couldn't find anybody, and we had to go, and so my partner was appointed by the court as what's called a curator, which is not quite a personal representative, but it's someone who the court appoints as a neutral party to gather the assets. We had to clean out the apartment, and in all of that, we found a locket. And in the locket, we opened it up, and there were pictures of two young girls. It turned out that this man had two daughters. He was dead. He had two daughters that he had not seen in 50 years. We found them. And they inherited the property. And that they, I mean, it was obviously a sad story, but when they realized that their father still had a locket, it was very touching, a locket with their picture from all those years. You know, back, and this is a while ago, so let's say 70, 80 years ago, either when people came over from Europe, or there was the Depression, or whatever, or World War II, whatever happened, families got broken up. Not by choice, but either for economic reasons, or something happened and kids got sent to live with relatives, and people, or you know, young families, they got divorced and the father never saw the kids again. Stuff happens. And you know, there are some really unusual situations where it can come back. So
in a case like that, you'd have to do a lot of publications in the newspapers and
yes,
knock on doors.
yes, but the problem is that it's legally sufficient, but it's practically not. Because the person that's sitting in Cedar Rapids, Iowa, is not reading the Daily Business Review in Broward County. Okay? Yes, The standards are a newspaper of general circulation in the county where the property is. There's stuff like that. Same thing for constructive service and process that we're talking about foreclosures. But in reality, it doesn't help. You're much better off dealing with things on the internet and you know, the search, and there are search companies, genealogical search companies that can find things much deeper. You go through Ancestry.com and find people that way.
How far back does the Homestead creditor thing go? Like, if they have
To the
like,
Constitution of 1868.
so if they have 2 mortgages and they have outside creditors and it's their homestead and the person dies, all that stuff is wiped out?
No. No.
So then what happens with that?
Okay, so you're delving into Homestead, which is very complicated. The exception to forced sale is a consensual lien. A mortgage is when the person actually signs the document and says, yes, I agree that the mortgage is on my homestead. I need the mortgage to buy the homestead.
Okay.
That's enforceable. It's forced sale, like your gambling debts or the slip and fall case or things like that. Those are the ones that you can't attach the homestead with.
So there's like a property that has been vacant for like probably 10 or 12 years, and nice property.
Who's paying the taxes?
I believe the mortgage company.
Why
But
aren't they foreclosing?
I don't know. I've come across it a few times where I guess it just gets lost in their books. They're paying the taxes, but the property sits there vacant. There's another one in Lake Worth, same thing.
That's weird.
But
That's
it's
an aberration.
it's like impossible to like solve though. I kind of gave up on it. I didn't know what to do next.
Okay, any other questions? Let's take a break, and then we'll come back and talk about title examination, title insurance, abstracts, and other fascinating things in real estate. Sorry, this is going to, today is our dry day.
So I have a question. So, actually, own the property with somebody else, and they were on the
Watch out, you're gonna charge you some money.
We're trying to basically protect the house and the so when I spoke to another attorney, he said, trusts that will protect it from the
You better open an LLC.
Yeah, but the problem was the due to mortgage.
Same thing in a trust. As soon as you transfer title, so ask the bank. Tell them that it's still the two of you. You're not transferring the property. You're not doing anything like that. You just want to put it into an LLC. Just get the permission.
And then you just do it that
And
way.
do it that way. Just ask the permission.
It's cheaper too, I think, that way too.
Well,
Trust is.
the trust doesn't quite do what you want it to do.
Yeah.
If you're looking for liability protection, the trust doesn't do
It
it.
doesn't really
No.
know. Wonder why. He said.
I haven't seen him. Oh, you got one? Oh, I'm sure.
Oh, you do?
Yeah. You're dying?
I'm like at 3%.
Oh. Oh, no. I'll into my car.
How do we remember all of this? How do we remember all of this?
There's like the online textbook. Or like take notes.
Yeah, no, I'm taking notes. I'm trying to figure out how am I going to remember all of this. Some of it I know already. But what are you doing? You said there's an online what?
If you buy the textbook.
Or the textbook. But didn't you say that the textbook don't really cover the stuff?
I mean, he just covers it by lecture, so.
How are you doing the quiz?
I've been doing it, I got like a 60 view.
Oh, really?
Yeah.
Oh, 90.
90,
Yeah.
I messed up on like 2 questions, that's why. So,
Oh, that's why.
yeah.
So, do you want to take the midterm?
I'm pretty sure I'm gonna take it, yeah.
Yeah. If I do well on the other one, because I didn't do well on the first one, got like 60 something. Then I got 80 the last week quiz, and this quiz I got a 90. So if I get another passing grade.
If I do good on like the 4th one, then I won't take it.
Yeah, yeah, but I didn't I messed up only with one question, but I don't know what I did wrong, or just with like small numbers. Probably something I didn't probably erase something on the calculator or anything like that. Yeah, but he's like, if you don't put like the right answer.
So right, like one thing missing, and you're like, you
yeah,
can't make it wrong.
and he will take out everything.
Yeah.
So he's one of those professors that just looks at the results and all that stuff. So he
I thought I was like, okay, I'll get an 80, I got like a 60. So.
Yeah, but like when he said like, oh, 10 minutes left, I was like.
So you never said that, you know?
Yeah, I was on the.
freaking out, like,
yeah, I was
to-
on the 7th question. Just finishing with that question, I was like, oh, like the other 3s, I gotta do it like really, really fast because otherwise I'm just gonna get a bad grade. I was like, I don't wanna get a bad grade.
So I don't know, I might.
But you know, it's just calculator, so you have to use a calculator. Like on the first quiz.
Yeah, that freaked me out, you know.
That freaked me out because I was like, if all the questions are gonna be the same using like those buttons, I'm gonna be just trying to on those questions.
Like the second quiz I got 100, so I'm like,
Oh, yeah.
okay, you know, the third
So
one.
just try to get another one like that, and you won't have to take the midterm.
Yeah, I mean, I don't think I will have to.
Yeah, because that one is a close book.
Yeah,
So
you need to
imagine,
know all the numbers.
like, yeah, imagine like trying to remember everything, so you're just
Like
gonna
not.
be really bad. Yeah, even when I see my notes, I mess up stuff.
Yeah, you know, just looking at it. you're
Yeah,
really
just
confused
looking
and
at it,
the-
you're just messing
the
up
shift or
everything.
whatever, yeah.
Like especially like those, like the calculations, like the present value, future value, all that stuff. So it took me some time to learn,
Yeah, it's different.
to learn from that. I don't mind myself like seeing the calculations just by myself without the notebook. But just try to get a new good score, and you'll be fine.
Yeah, I'll just see. So.
Yeah, just get a passing grade.
Yeah.
At least 80. So if you get an 80, then you
Yeah, I should be
like,
fine.
like from 80 above. And
Yeah,
above.
for like the
Obviously, if you get a
fourth
90 or
one,
100,
yeah.
it will be better.
Yeah, right.
Yeah.
Did you take him for like financial modeling or?
No, didn't teach that.
Oh, I see. But now he teaches it. So.
Oh, you're lucky.
Really? Okay.
Most of that.
Like
You would've
40?
had it with- Yeah, if you would have had it with me.
What Miguel was worse? Or? I mean, I've heard that he's worse.
You didn't learn how to financial model until the last 2 classes. You wanted like, it was before you.
He's a really good guy, the professor, like 40.
Yeah.
He's really good.
He's
Yeah.
a really good teacher.
Yeah.
You just gotta like, just take good notes, and I think you'll. And have you taken another class with him? Other than
Before?
this one? Oh yeah.
Just finance last semester and this.
With
I
4G?
have to take it for like construction.
With 4G?
Yeah.
And it's gonna be the same like quizzes, all the classes with him? All?
Same way.
Because I have him for like construction principles.
Yeah, me too. Me too. Like
For,
next,
like,
yeah,
next-
like
like
next
Did you
half.
teach him that?
Yeah.
Oh, I had no idea.
Yeah, principal,
Mine
construction
don't show
principal.
up the teacher, it's just blank.
Yeah,
And he's
I'm
for
taking that one too.
Real estate
Development, yeah.
Yeah, that's.
Are you doing summer too?
I don't know yet. I'm just doing. I can check.
I gotta do summer. I'm an international student. So.
Yeah, so you have to take that credit.
Yeah,
load,
I gotta take everything.
I mean, I think I also have to take summer, like 2 classes.
Yeah, I was like, oh, I want to take like the whole semester, and then I'm gonna take my summer off, and this girl who helped me out told me no, you gotta come and do the whole semester.
So how many classes do you have to take for summer?
2 classes. But it's gonna be whole summers from May to August. I thought it was gonna be just 1.5. I was like, okay, finish just 1.5, I'll be fine.
Like I take construction principles.
Yeah, 1 and 2.
Well, yeah, you're right. It doesn't say 4G. I just have it blank, but I think it's 4G, right? I think it's
Yeah, 4G. Yeah, I'm taking another class with 4G next half, I guess.
like I'm taking development next half, like 8 a.m.
Are you taking the online class, like software
now?
development? Yeah.
Yeah.
I'm taking it now.
I have to start this stuff on that.
Oh yeah, I was doing I was doing the case.
Well, I kind of started it, right?
Yeah.
So I'm like halfway through, but
I got to I finished module 4.
So you did the whole case?
No.
Yeah,
Like
I
the
finished
one you
module
did,
2.
or like the
I
new
gotta go
case?
through 3 and 4.
Oh, okay.
I didn't start the case on my own.
It's a little bit confusing, like towards like, the thing that gets a little bit boring, so it's like,
Oh yeah.
and then you start kind of
Because you
messing
gotta
it
stay
in
with the
back,
whole video and see
Yeah.
everything.
and then trying to keep both screens up, it's kind of tough.
Yeah, I finished module 2, and I gotta go through 3. I get 3 is just really short, but 4 is really long.
How exactly is it split? It's like Kate module 1. And then if you, it's hard to follow flip. That's what that's. Like, I just followed the videos.
Sorry, you came in late. What is your name?
Johnson?
Okay,
Johnson, Robert.
I just want to work you up for it.
Casey's the same, right?
That's what I'm wondering. I don't know.
Yeah, that's really confusing.
But then he also moved it, right? Because
Yeah, from like what's gonna be
3rd to 10th.
3rd, yeah, to
But he didn't like change the.
yeah. I think he did.
Yeah,
Yeah,
right.
just go and check.
I got you. Yeah.
When is our midterm?
2 weeks.
Are you gonna provide a review?
What's that?
Are you gonna provide like a review, like a class, in-class review of content or what?
I was asking a question just when you went outside. You know, how much of this would, well, you know, as young people, I'm sure we retain everything 100%. But what happens if you don't retain 100%? Are you expected to remember all of this? In other words, I'm trying to get a feel as though, you know, since we're not using a textbook and we don't have any secondary source apart from the internet or something like that, what do we do to kind of supplement the notes we take and so on and so forth?
Well, that's why I provided the outline, and I know that's difficult, and I've thought about that, and I don't quite know how to solve that problem, because you know, and I'm not gonna test on these tangential discussions. I'm trying to, well,
I got
you
you.
got
No, I
it.
understand.
You know, I got a friend who did this. We have a lot of that going on, and that's fine, because it's interesting, and it's things I know, and I could almost accuse people of looking for free advice as to how to make money, but I would never do that. But I'm not going off on those, you know, that's not what I'm looking for. Things that you hear me repeat 2 and 3 times, yeah, it's probably I'm going to say this is important. Stuff like that.
one of the things I always use the same advice, same information that James was using, the joint tenants in common and so on. Those are on the broker, the real estate broker's exam. That's how we remember. That's how I remember that. But I never got past the three items, what they stand for and who they relate to.
Now you have. Now you know. Now you know. Because now you're getting real estate law, which is important.
I mean, the LLC is worth its weight in gold right there with the protection. No one tells you that.
Well,
okay, so let me ask you a question. You say no one tells you that. What do you think is the purpose of having property in a corporation or an LLC?
No, the purpose, like having two people. As
Oh, okay. That happens to be a Florida quirk.
Yeah.
And I'll tell you. All right, we still have a few stragglers now.
And then just really quickly before you go into that, I know that when we spoke about it, you said that they can only go after what it's generating. What exactly can they go after if there's two people on that? Like what? They can't take the LLC.
It's one person. Only the person does.
Okay, so it's.
Yeah, but
It's not. It's kind of like. It's kind of like a charging lien. It's basically a lien on distributions. Is this on or off? Let me turn this off for the breaker now.
it's on.
Okay, good, fine. So if there's multiple owners in the LLC, then the creditor of an owner, of a member, gets a lien on the distributions of the member. Okay? Which means if, let's say we own a piece of property together, you and I do, and it's got a 30% vacancy, and we're paying the mortgage, we're paying the expenses, we're not taking any money out. Okay? They're not going to get anything because I may owe them money, but I'm not getting anything out of the LLC. On the other hand, if we're 100% occupied, and I say to you, look, do me a favor, let's just leave the money in this year. I got this problem over here. But otherwise, I'd be entitled to cash flow coming out. Theoretically, that creditor could take us to court and say that we're deliberately holding back distributions for no business reason and force the LLC to make a distribution, theoretically.
Or then does that happen?
Does it happen? I'm sure it does, but I can't tell you I know for 100%. Because, you know, people try to protect their assets. Now, I have seen real life situation where, you know, you try to structure that this LLC owns this LLC owns this LLC type of thing because you've got all those protection things you're trying to do. In the middle, there was a single member LLC that owned the LLC that owned the property. The member of the middle tier was a company down here that had a problem with another property in another state and got sued by the bank. They got a judgment against the bottom owner that owned the single member LLC. The bank executed on the single member LLC to get paid and took control of the single member LLC, owned it, took ownership of it, which all of a sudden they owned the property because that single member LLC owned the property owner. And that's where you can have a problem. It's unusual, but that happened.
Is that what they call piercing the corporate veil?
No. Piercing, here's the corporate veil part. Good question. I'm happy that's good because it gets back into some of the details of it. The corporate veil, if you will, is the liability protection. So that if the corporation has a legal problem resulting in liability, it does not reach you as the shareholder. Okay. If you have shares of General Electric, you don't have anything to do with the operation of General Electric. General Electric has its own books and records. Its properties are completely separate. But if you own ABC Corporation that you formed just because your lawyer told you should have a corporation to own your property, and you take your rent checks and you put them into your personal account, and when you go to Publix, you use that same money coming out of the corporation, or even you take the money out of the corporate bank account and use it at Publix. You have a corporate credit card and use it at Publix. And you're mixing the identity between you and that corporation, so you're not observing the corporate formalities. And when I ask you, do you have minutes of your meetings the last 3 years?
No.
When I'm the lawyer with my name on the side of the bus, and I said, where are your minutes of your meetings for the last 3 years? Oh, I didn't bother with that. So you're not observing the formalities of having a corporation. It's really you. It's an alter ego. You just have a name out there. In that circumstance, since you're blurring the difference between you, the person, and the corporation, that's where I have the opportunity as the PI lawyer or the judge representing a creditor to say, I can come and take that from you. I can hold you personally responsible for what should have been the corporation's obligation because you have treated it loosely. Okay? That's piercing the corporate veil. It's a good question.
That's my story, and that's everybody's small business.
It's so easy. It is so easy. We used to, I mean, I don't know, I don't do this, but we used to charge like $50 a year for somebody to do a one-page minutes and say the directors had a meeting on December 31st and they elected A and B as president and vice president and they said we had a good year and they made a distribution and that's it. We both signed it and put it in the book.
At the end of the
Why
year.
stop?
That's it.
That's it. That's you know, and the same thing. You're not taking the corporate assets and using it for personal. If you're going to make a distribution, you take money out of the corporate account and you put it in your personal account. Okay, and you say distribution, and it's on the books and records of the company. And books and records can be a sheet of paper, or in today's world, an Excel spreadsheet. Used to be a ledger sheet. Buffer green.
When you mentioned about, I guess, I don't know if it was the bank taking somebody to court or whatnot, because they didn't want to take a distribution that year, wouldn't, you know, they'd be able to say, well, you know, we're not taking distributions this year because we're trying to, you know, reinvest into our business.
That's a legitimate business purpose.
Okay.
In the situation, in the example I used, I just said to my partner in the business, listen, I have a problem, let's keep the money just sitting in the bank account. If you want to, if you, and again, you could do this, the safest way to do something like that would be to have a piece of paper, a minute, say, okay, well, this year we've decided that instead of taking $50,000 each as a distribution of the profits, we're concerned that the roof is going to have to be replaced next year and we want to reserve this money for the roof. Or, the LLC, we believe that the LLC has a business opportunity to acquire a second piece of property and therefore we're going to reserve this money for that purpose. And just stick it in the file. It's that easy. You know, they're not looking for you to have the formal minutes of a big company. They're looking for you to have something that shows that you're not playing games and that you and your entity are not the same thing.
And that you're playing by the corporate rules.
By the rules, or substantially.
What if you're a single member now, and then like, what do you have to do to alter to make sell like 1% or give 1% to a family member?
Transfer.
It's simple. Like
transfer. Yeah, there's pieces of paper.
I mean, not owning a property. I'm saying like your single member, like your LLC itself.
Transfer the 1%. It could be 0.5%.
You do up with a corporate resolution saying.
No, transfer shares. Transfer membership interests. Once upon a time, everybody used to buy a corporate book.
I don't even know where my corporate stuff is. Oh, you heard that one before, right?
I have heard that one before, yes. Where's your seal? In the aquarium, I know.
With the book.
Because nobody uses a corporate seal anymore, right?
My corporate seal, when it came, you press it, you don't even see the impression.
So it used to be the same thing with a notary. I don't know if you remember when you go to the notary public and they would squeeze the piece of paper. Okay, that's before the rubber stamps were okay, and there was a controversy because states up north had the rubber stamp and it didn't have the squeezy seal, and the clerks down here would go crazy. The title people didn't like it. Anyway, that's all been fixed. It's now it's a rubber stamp. It may be round and look like a seal. It may have a bird in a circle that is a seal. Trust me, that's what they look like. Same thing with the corporate seals. So in the days when they were what was called an impression seal, is what you're talking about?
Yeah.
And you wanted to record something, and you had to show that there was a corporate seal on the document because of the requirements for conveyancing. You took a pencil, or a piece of charcoal. Most people didn't have a piece of charcoal around because they got gas grills, but you had charcoal that worked just as well. A pencil, you went sideways very lightly over the seal, and all of a sudden it created a shadow. It was just enough to microfilm it, or scan it in today's world, but that's... And you'd see deeds and things, recorded deeds, and you can see where the pencil marks are. It's exactly what they did, it works. So, okay, now, title. Title is the heart of what I was trained to do as a young lawyer, and it's still a very, very important part of our practice in real estate, because if you're going to buy a piece of property, the most important thing that you want to know is that you get good title. No, good title. There's a difference. Okay? You want clear, you don't want problems, you don't want to deal with marketability. We'll talk about marketable, that's something else altogether, but you want to make sure that you don't have problems. You want to make sure that you want to make sure there's no liens, the simple stuff. You want to make sure there's no mortgages. You want to make sure there's no judgments against the owners. You want to make sure that there's no restrictions on the property, that there's no easements blocking where you want to go that keep you from building on it. So how do you find this out? How do you determine if the title is good? Well, what's that?
That's the job of your title company, right? To go do the title search and come up with all that stuff.
Yes, you sound like a broker. You sound like a broker.
Yeah.
That's an oversimplification. You don't want to just have that answer. You want to know what really goes on, don't you?
Okay.
So that title company, just so you know, that title company that you're talking about is an agency. It is an agency that has the authority to issue title insurance on behalf of a title insurance underwriter, a real title insurance company. Title insurance company names you might have heard of: Chicago Title Insurance Company, Fidelity National Title Company, Old Republic, First American, Stewart, Westcorp. Those are all names of title underwriters. They are the insurance companies that are insuring your title. The title company where you send the closing to, that's just some schmendrick on the street corner that's an agent that has the authority. And what they do is they go to the underwriter and they ask the underwriter, I'm jumping, but they ask the underwriter for number 3, a title commitment. That's how you, in today's real world, you find out what the status of the title is. A title commitment. A title commitment, you might know in insurance world as a binder. It is a promise to issue an insurance policy, a commitment. And what it says, the way it's set up, it's divided into 3 parts. The first part, Schedule A, says who's going to be insured, how much they're going to be insured for, who the current owner is, and what the property is. That's the beginning. That's Part A, Schedule A.
See that? So it was who, how much, the current owner, and what was it?
Property. If you remember from what I discussed it last time, or time before, the surest way to determine what property we're talking about is a legal description. Not a street address, not a folio number, a legal description. That's important. That's important. You know what that means when I say that's important, right? Write that down, you're going to see that again.
Come again.
Can you say that again? Just look at what the fuss.
The most important way to describe it, or sure way to describe a piece of property, is a legal description. Now, in a platted piece of property, we talked about platting the room and subdividing it. So what you have is, it would look, and I'm going to show you deed in a minute, but chair 1, row 1 of 2073, a subdivision, according to the plat recorded in plat book page, blah, blah, blah. Okay? So that's the legal description because it's platted, because that map is recorded in the public records, and that map establishes the identity of this lot. That's easy. The other way to describe property in the legal description would be what's called a meets and bounds description. Meets and bounds description describes describes the property by starting somewhere. For simplicity, I'm going to just use this room. Commencing at the door. Then 30 feet east, I believe east, roughly east, I don't know compass, but okay, to a point. Thence south 5 feet to the point of beginning. So you commence over there, you come to here, you come to here, you come to the point of beginning. Then it's going to describe 2 feet this way, 3 feet this way, 2 feet this way, 3 feet back to the point of beginning, and that's how you're going to describe the lot. That's when you don't have a recorded map. The other way to do it, and I'm going a little far for this because I really have intended to do this later on with graphics, is there's what's called a government survey where the entire country is divided up into a grid of sections, townships, and ranges.
It comes from Tallahassee.
Yeah, the Tallahassee is the Tallahassee Meridian. And basically, a section is a square mile. I believe that's what it is.
But that's the older system, that's not a...
That is not the old system, no. All of what I just described is for real and it's still in use. Okay, and I'll bring examples in later, but I'm getting a little past this because we want to talk about the title commitment. Hold for a second. Before that was common use, when I first started practicing, I told you I practiced with Brett Flintstone, we had abstracts of title. And I did intend to bring the abstract to show you what I got lazy. So an abstract of title, in its simplest form for the house lot, is about the thickness of a phone book. Legal length and about the thickness of a phone book. And that contains copies of every instrument pertaining to the title, beginning with the transfer of Florida from the King of Spain to the United States. And everything from there forward until the last title transaction. It's a complete history. And so what we used to do is we would read it page by page by page and trace the ownership of the property and make notes if there were liens. And at the end of the day, you'd have your notes and you'd know what affected the property and what didn't affect the property. Essentially, that's what the title underwriters do when they create the title commitment. But they have a slightly different way of doing it, and they don't go all the way back anymore. And the reason they don't go all the way back anymore, I'll talk about in 2 more things.
So what has copies of every instrument? And then
every instrument. Well, in the early days, there's a paragraph. It's not a copy. But once you get, say, into the 1940s, it would be an actual photograph of the instruments. So you have that on your desk, and then there were computer printouts that you could have in your office. Once it got a little more modern, when I started practicing, which was in the late 70s, there was a computer. And just to give you an idea of how this worked, the computer would be sitting with a phone hookup, and you have to dial the phone number, and you hear these weird-ass noises, and you put the phone receiver into the cradle of this thing, and it would make the noises back and forth, and it would communicate with a computer somewhere else, and then you'd be online. Okay, there was no internet, there was no America Online, there was none of the good stuff that we had. This was actually a dial-up into a server somewhere else over the phone line. But what they would do is they would give you a certified printout that would continue the abstract from the last time that the plant created it and gave it to you with the copies, so you could actually, and then you could order the copies sent to you the printout just had a paragraph for each entry, and it was the same as the abstract. You would evaluate what was in there to see what the title was, and from that, you would create your title commitment.
So this really would be an update from the last time
Exactly.
the title was checked till
Correct.
present.
Correct. And there was always a time period between when that happened and when the closing took place, and that's called the gap. And I'll talk about the gap and what it does a little later. So the title commitment is a binder. I went through the first part of it. I told you the who, what, when, the how much, and such. The second part of the title commitment, which is called Schedule B1, tells you the requirements. What things have to happen for you to have title insurance on what you're buying? What has to happen? you have to have a deed. You have to pay off a mortgage. If there's a mortgage involved in the closing transaction, or there's going to be title insurance for the lender, there has to be a mortgage. And it will say things like, let's say the property is owned by John Smith, it's going to call for a deed from John Smith, joined by his spouse if married. Or, in the alternative, if the property is not homestead, an affidavit that the property is not homestead, and where Mr. Smith actually resides. Because if it's not his homestead, then you don't need the spousal jointer. Same thing with the mortgage requirement. Then you're going to have proof of payment of taxes as a requirement. And then all other things in there. If you're dealing with property coming out of an artificial entity, then there'll be requirements in the title commitment that we talked about before, showing that the entity exists. They'll want to ask for a certificate of good standing from the state. They're going to ask for a resolution from the board of directors that authorizing the transaction. They're going to ask for something from the members of the LLC or the limited partners of the limited partnership, something authorizing the conveyance. So all requirements are going to be in there. They're going to ask for proof that there are no municipal liens. That's some of the municipal lien search to make sure the water bills have been paid. All of these things are requirements that you see in a title commitment. And once all of these are satisfied, then you go to the next part of the title commitment, which is Schedule B2, which says, these are the things that your title is going to be subject to. They include things like the plat, the recorded map that shows the property, subdivision restrictions that say that you have to have your horse trails, and you can't have farm animals, and you can't have manufacturing on your residential lots. Those are all restrictions on the use of the property. All those things are going to be in Schedule B2. And those have to be examined very carefully in a commercial setting to make sure that there's not something on there that causes a problem for the use of the property. For example, it could be property, there could be a statement that somebody had on there that says there can never be alcohol sold on this piece of property. Why? The person was very religious. They had a problem in their family. Grandma was part of the temperance movement, and they'll never have alcohol touch their lips, and it was their property, and they're going to sell the property, and they can do whatever they want because it's a contract. They're putting a contract on the property, a deed restriction, forever. And it happens.
But those are no longer valid, then throw those out, no, right?
Absolutely not. That is completely valid. You can't, what's invalid is a restriction that says, and I think we talked about this a little bit, based on race, religion, national origin. That's invalid. But something that restricts the use, it's like no alcohol, or well, it's not usually in the deed, but if in a lease, I do leases, like for example, I think it was Outback and Pizza Hut, I forget who it was, had a provision in their lease that said that the shopping center owner could not have a dispensary in the shopping center, a cannabis dispensary. And it's in a lot of leases like that, where the big national companies put that in their leases and prevent it, because that's their policy and that's what they want by contract. That's going to be a problem at some point in the future, but right now it's not so much of a problem because they can't get mortgages on this. You can't put it in there if you're going to have a mortgage, so the shopping center is always an issue for that. So, all these restrictions are going to appear in Schedule B. Then, after the closing, after the deed is recorded, after the deed is recorded, then you're going to get a title insurance policy issued by one of the underwriters. It may come from your local title company, which you think of as the agency on the corner, but it's going to be issued by them as agent for one of the big underwriters. Just as if you go to get insurance for your car, you may go to your friend, the insurance agent, but it's not going to be John Jones who gives you your policy. It's going to be Allstate or State Farm. Same idea. The Marketable Record Title Act, so somebody raised a question about time, as to how long restrictions are good and what happens. So, the Marketable Record Title Act is a Florida statute that helps to clean title. It goes back 30 years, and if there's a conveyance that is of record more than 30 years, then anything before it can be wiped out. And that's where you can get rid of some of these wild restrictions.
Can you repeat that? If there's a conveyance, that what?
If there's a conveyance that has been of record more than 30 years, it's called a root of title. That root of title under the Marketable Record Title Act can wipe out something that's happened prior to it, with a few exceptions, like mineral reservations. Unless somebody comes forward with a notice under the statute to say, hey, I'm still here. So like, for example, if there were restrictions, a private owner, my no alcohol, let's say the no alcohol deed restriction was recorded, when was Prohibition, in the 30s? Okay, so let's say they recorded it in 1937. After it had been repealed, I think maybe in the 20s.
I was gonna
Whatever,
say
20s. But let's say they recorded that restriction in 1937 because they really were against alcohol. And that was in a deed. And it says, this property may never be used for the sale of alcohol. And that's never mentioned again. It's never repeated in another conveyance. There's no other notice of it except for that 1937 deed. Time goes by, and in 1950, there's a deed to your grandparents, and there's no mention of this restriction. And now that deed has been of record for more than 30 years. Under the Marketable Record Title Act, the deed to your grandparents is a root of title, and it's wiped out that restriction.
Because it wasn't mentioned?
Because it wasn't specifically mentioned. And a simple statement, all conveyances of record, or all restrictions of record, is not sufficient. The only way that can be preserved, two ways. One is if the deed in 1950 and every subsequent deed says, subject to that restriction, and mentions it specifically, either by words or by reference to the deed that contains it. Or if the holder of the restriction files a notice before the 30 years runs, preserving it, which the statute allows for. So it's a way to clean title from old things.
That wouldn't, I was looking to buy this piece of land to do some development some time ago. And it fell apart because the owner said somebody just came out of the blue, co-signed for him for getting the mortgage, and then disappeared. And 100 years later, the guy could never be found. Could that be absorbed under this marketable title type stuff?
Hold on. Yes. So first of all, someone doesn't come out of the blue and co-sign a mortgage. What probably happens in your fact pattern is he found somebody that would co-sign and gave him an interest in the property. So he was on the deed. Just being on the mortgage doesn't give you an ownership interest in the property. One is an asset, one is a
I
liability.
think he was on the mortgage. I think he was on the deed also.
Okay, so on the deed.
Okay.
So, when did this happen? Give me a date to play with.
I start stuttering. I don't even remember. I'm not even sure.
Okay.
Don't even know.
So,
I only got a phone call that it died because being died because of it.
okay, so it's probably much more recent than that would apply to. So let's say that happened, do my math for a second. Let's say that happened in 1987, okay? And the guy vanished, and in 1989, the other guy gave you a deed, okay? Without the signature of the first person. And now, 30 years goes by, and we're in 2019, okay? Now, you've had that deed undisturbed of record for 30 years. Other guy is gone, and he's never come forward and nothing.
Okay.
You've now extinguished his interest. Because there's another deed, which against his, which is bad for his interest, and his interest is, okay? That's
I should have known.
We gotta go back 30 years.
No, none of the attorneys in New York, none of the people involved in the transaction.
You wanna know why?
Know what to do.
What did I say about the statute?
Florida.
Florida. So you give me, keep your stories local. I can't help you with New York law. New York law is very different and has all kinds of different rules. They even call their deeds by different names.
You mentioned, Professor, that there is a difference between good title and marketable title. Can you please explain what that?
Yes. Marketability is standards that have been established over the years by the bar as to what constitutes marketable and not marketable. Good title can be just free of encumbrances, and yet it may not be completely marketable, which means that someone's going to make objections to certain things even though there's not an encumbrance. There could be some flaw in it somewhere.
So Schedule B, clear title, or marketable title, what is Schedule B?
Schedule B are the exceptions in the title policy, things that the policy says, very simply at the top of the page.
What's required?
Now that's B1.
Yeah,
That's
so
requirements. B1, now B2, the exceptions say,
For B1.
this title insurance policy does not insure against the following matters.
Not for B1 though. B1 is what's
Requirements.
required for what?
To issue the policy.
But
To insure the people, to insure the buyer.
But it requires clear title, marketable title, insurable title, like what type of
In a
title?
policy, it's insurable because you're getting insurance.
Of course, but like what is the word that you would deem that encompasses everything? Like clear title?
Good, marketable, and insurable.
Okay.
Sorry, I mean, I hate to do that, but it's everything.
Marketable and
Pointing title, what is that?
We'll get there. That's a legal action to get rid of stuff, clear things up. Save that for the litigation. So, now you have a problem. You go to get your title insurance, and they find something in the search. And now we get into a dispute. Is this really a problem? Who makes that decision? Where does that go? So it goes to underwriting at the title insurance company, not the agency, the company. And you go to them and you say to them, look, there's a little problem with this deed. The deed in 1960. No, I'm going to come forward more. The deed in 2010, the legal description was missing a word. Now, we can all tell by looking at it what they meant, but the word is missing. So the legal description's a little bit off. For us to go back 10 years and find the people and get them to sign a corrected deed is going to be impossible because they're dead, they've moved back to Europe, something, or they just won't do it. Now you go to underwriting, and you go to ask underwriting to make a business decision to say that this is really okay. Some defects, minor defects, for example, there's a defect in the notary block, the acknowledgement. There's a defect in they only have one witness instead of two witnesses. Those are cured by statute, some after 5 years, some after 7 years. But where you get underwriting to make a decision, now there is still that flaw in the public records. And that's the difference between insurable and marketable. Marketable title, there'd be no issues. Insurable title, underwriting makes a risk decision, because it's insurance, that they don't have a real risk by this one word missing in the legal description, that the legal description is good enough to insure the title.
That's not marketable.
It's not marketable. Because there's still technically a flaw in the public records, which you are choosing not to fix. Okay? And then what happens is, once you get that insured, you can keep insuring it forward.
Really?
Yes.
So once...
One insurance company will rely on the previous insurance.
But sometimes title companies won't insure some things, and you can take it to another title company and they'll do it.
Because underwriting evaluates the business risk. It's
Well,
all about risk.
So like, let's say that one wouldn't do it, they went to the next one, they would do it. The next time that the property sells, the sellers end up going back to the original title company, now they've insured it?
Well, now because they're relying on
Them.
the owner's policy that's already been issued.
So they would?
Yes.
Really?
Because if there's a problem, today the current company can go back to the previous company and say, hey, you insured it, hey.
Really?
what it is. They have the right to rely on the property.
Is that like chain of title, or what is that called?
So
Chain of
it's
insurance?
insurance. So what's happened is the abstracts that we used to use are gone. We don't use those anymore. First of all, there was a fire at the plant that got destroyed in Palm Beach. Then later, lawyers stopped going through this. It's a lengthy process and it's huge amounts of risk. I've talked about some of the deals I've closed lately. I don't really want to be insuring a $20 million loan based upon my examination, even though I could do it, absolutely. I'd rather have the underwriters do it and have the title insurance standing behind that. The lenders insist upon it. But instead of having the abstracts of the certified printout, now we all rely on the title commitment and the title insurance to determine what the title is. So, when you go to sell your property, the first thing your lawyer or your real estate broker is going to ask you to give them is the prior policy. Your owner's policy, that's your proof that you own it. So now you're going to pass that along to the next examiner who's going to look at it and go, okay, I'm going to start from here because I have a good policy that says, as of this date, it is valid. Title insurance will insure against things that you can't see. Maybe it's a forgery back in the chain of title 15 years ago. Maybe there was an error in the legal description. Maybe there was some other flaw in it. Once it's insured, it covers it. What title insurance does not insure, this is important, title insurance does not insure value. So, as the date you buy your property, you buy title insurance based upon the value of the property today. That's the amount of your insurance. If the title problem comes up in 5 years, and your title and your property has doubled in value, they don't come along for the ride. You have an insurance policy based upon what you paid for it. Title insurance insures against fraud, mistake, not value.
So when the property appreciates in value, and if there's a problem with the title, you get what you were insured for originally, not the new value.
Yes, the only way you'd have to have another transaction and an appraisal, like for example, let's say you've had the property for 10 years and it's doubled in value, and now you're going to do a cash out refinance. You're going to go and you're going to get the title examined for the bank. At that point, you can pay to have a new owner's policy issued at the new value if you present the appraisal. You're going to have to pay a premium, you get some reissue credit, but now you can bring your insurance up to your current value.
Would your taxes go up?
What's that?
Would your taxes go up?
Your taxes go up based upon assessment. That's nothing to do with title insurance.
But like you have to get an appraisal.
One thing has nothing to do with another.
Okay.
Appraisal's private.
Okay.
The assessor, though, also appraises. The assessor looks at your property taxes, but in that case, remember, your assessment is capped, especially if it's homestead. It's capped at 3% of CPI, whichever is greater. Sorry, whichever's less.
On investment.
Investment is 10% until there's a title transfer. Commercial properties without a transfer, I think it's 10% cap on assessment changes. Because remember, we have a problem with that when it comes to commercial leases. That's next week, but you have pass-throughs in leases, which means that your expenses, including your real estate taxes, of the landlord can pass through to the tenant. They expect taxes to go up periodically. All of a sudden, the landlord sells the property to a new landlord, and the assessment, which has been capped based on that law, is now reassessed based upon the new value. The real estate taxes go up. All of a sudden, guess who's bearing the burden of that? The tenant, because it's being passed through. The poor tenant just sitting there doing business. They weren't expecting this. Because the landlord sold, the taxes go up, their monthly check goes up.
What makes the taxes go up when you sell?
So, okay, the assessment, the increases in assessment are capped at 10% a year.
Well, okay, so but then what? Like even
Except when you sell, then the cap goes away and it's reassessed.
Okay. Like on a new value of the property?
Yes, current value, whatever the property is when the title transfer takes place.
Based on sale price though? Or like...
That's one of the factors.
Okay. Because if you add value to a multifamily that was 40% vacant and you fill it, now it's worth double what it was worth. Now you're gonna be taxed on the value of.
You're taxed on the value, not how you got there. It's ad valorem taxation. It's based upon the value of the property. Question?
Title insurance, whose responsibility is for the buyer or the seller or the tenant?
Depends on the county.
Oh,
It's by contract, but depends on where you are. In Dade and Broward, the buyer pays for it by contract almost all the time. Other counties, the seller pays for it. Commercial, it's up in the air, it's negotiable.
Title insurance?
To pay the cost of the title insurance, yes. In fact, if you look at that contract, I don't know, I think I may have given you a commercial version that I gave out, that I distributed, but on the residential, and maybe on that one, I don't remember, there's actually check boxes as to who pays. And there's actually a box called the Miami-Dade and Broward special provision. And in that one, the seller pays for the continuation of title, which basically means the commitment, whatever the search fee is, $200 to $300, and the buyer pays the premium. In other parts of the state, the seller pays for title.
Isn't it kind of risky from from a point of view of a lender to have the seller paying for the title insurance? To me, that's almost a conflict of interest, because if I'm selling and I know there's a problem, I just sort of forget. So I'm not going to remain with that,
You're not doing it as the seller. You're just hiring somebody. You're just hiring a closing agent who's hiring a title underwriter who's doing an examination. You have no control.
I'm saying in the event where I personally knew of something that affected title.
Yes.
Let's say, for example, grandma died 2 days before she went to the closing and signed. If you get my point?
I got it.
And why would I say anything? Why would I, if I'm the seller, I'm not going to say anything. If I'm the buyer and I knew something like that, unless I know it's going to come back and haunt me and I want the property, well, I'm going to take it. Grandma is not going to come back from the dead. But, I personally think...
What size bracelets do you wear on your wrists?
What size bracelets? No, let's not answer that question.
You're talking about fraud.
Yeah.
It has nothing to do with who pays the premium.
That's why I'm saying I
It
would
has
not
nothing. Let me ask you a question. Let me take your example, even if it's not impossible. It's a little far-fetched, but it's not impossible, and I have seen it happen. Literally what you're saying, and worse. How is the payment for the title insurance going to change your behavior?
It's not. The question is not how the payment is going to change.
That's all we're talking about, though.
The fact is that if I'm the seller and I know that there's a cloud and title, a problem. If I am paying for it, if it is my responsibility to make or break the situation, I'm not going to pay for it. This is why I'm saying
you agreed in the contract to pay for it.
I'm saying,
you don't have a choice.
What I'm saying is it's in the contract, but I personally prefer the buyer to pay for title and for their side to get title, so that when they get the property, they don't have a problem with the title. That's just my
But okay, so when under your circumstance, then I don't want to spend too much more time on this.
Right.
Under your circumstance, the buyer has now paid and selected the title agent, and you're still signing grandma's name to the deed. You want to tell me how you fix that? How did you shift the responsibility to take care of your fraud? It didn't.
True.
Okay. The same way I had a guy. Worst thing you can do for fraud, unfortunately, if you have bad people involved, is name your son Junior. Because I had one, and Junior appeared at the closing to sign the mortgage on the property 3 days after Dad died. And he just left the Junior part off and signed his name and mortgaged the property. It was his name, but okay. Title insurance, by the way, title insurance will protect the buyer from your fraud. Because unless somebody knows about it, and it doesn't matter who pays for it, but unless somebody knows about it, that title insurance will protect the buyer from your fraud. That's why you buy it. if I've mentioned this. It's just a little off to the side here. Does anybody know about FinCEN? So we have, our federal government has targeted certain areas of the United States for money laundering and moving of illegal funds. And you may be surprised to know that Dade, Broward, and Palm Beach County are part of that group.
No way.
Can you believe such a thing?
That's the first time I'm hearing that one.
So if you are buying real estate, residential real estate for cash with no mortgage, and I forgot what the dollar amount limit is, it's not all that big, and there's no mortgage involved, and it's anything other than an individual human, which means any kind of an artificial entity or trust, there's a federal reporting requirement. And it's in these 3 counties. I know it's in New York, the New York area, and maybe Los Angeles, and there may be a couple of others. They are targeted, specifically targeted.
How recent is that?
2 years maybe?
Does the title company do that for you?
The closing agent, yes. Whether it's
What is that requirement called?
FinCEN. Financial. I don't know the exact name of the act, but I wanted to make sure to mention it because I have notes on it and I wanted to just make sure of it. Sorry, I'm just going through some notes.
That's something we should know about, right?
You should know about that generally.
Yeah.
I don't.
Financial reporting requirements.
It's for cash transactions on residential real estate, other than an individual human. Okay. Let's talk about types of deeds. First and most important thing I want to tell you about, let me see if I can make these. So we're going to talk about warranty deeds, special warranty deeds, quitclaim deeds, trustees deeds. All of these deeds will convey title. So don't let anybody tell you that a quitclaim deed is no good. A quitclaim deed conveys whatever the grantor has. But if the grantor has it, you get it. All these deeds are good. Give me a second. I want to show you what the differences with the deeds look like. Upload them, but I'm going to eventually, so bear with me for half a second.
Just one quick question.
Go ahead.
When we talk about cash in nature, we're not necessarily talking about the case where the guy turns up with a suitcase full of money. We're talking about where there's no mortgage involved.
Correct. Oh, look, I got one. All right, so this is a quitclaim deed. It's the simplest form of deed. And what it says, in fancy words, but you can see it really clearly, is all the right, title, interest, claim, and demand which the grantor has to the property. Obviously, there's no legal description filled in. To have and to hold. I'm giving what I have, you get. What's missing from this document is any representations or warranties. Now, it's used for gifting in a lot of situations. It's used to clear problems. If I think you have a claim on my property because of something, you didn't give me a proper deed before, you may have been a hidden heir or something. I will go to you and I will say, look, I'm not asking you to tell me, yes, you have something, no, you don't have anything. I'm just saying, whatever you have, just give it to me. Now, that doesn't necessarily mean that people are going to do it. I had one of those wonderful situations where the developer was trying to convey a lake to, they owned it privately, it was a man-made lake, and he was trying to convey it to the Property Owners Association. My client owned an unplatted piece of land, which was basically a giant rectangle, maybe a square, and a third of his rectangle was in the water. And yes, you can own the bottom of a lake, it's private. So, when the developer created the legal description to convey the lake to the association or wherever he conveyed it, maybe he conveyed it to the other property owners, he went around the perimeter of the water, which is what you would think would be the normal way to describe the lake. In doing so, he inadvertently clouded title to a third of my client's property, even though it was under the water, and gave it to the neighbors, who were the association people. Okay? No, it wasn't so. What we did was, we called a meeting. We called a meeting at my client's house of his neighbors. 5 families, 6 families that lived on the same block. We know, most of us knew each other. We all had kids in school together, not too far from here at University School. And or we knew each other from the neighborhood, doctors, lawyers, business people, but just neighbors, all neighbors. And I came and I explained, I gave them a chart, and I said, this rectangle, this square, screen if you will, is these people's home. This is their legal description, this is what they own. Your deed that you just got from the developer came right here, just like that, around the lake. And you accidentally got this much of their house. All I'm asking you to do, folks, is to sign a quitclaim deed back to my client, your neighbor, for their house. The same description that's on their deed to their house. I just want you to say that you have no interest in it. Not one person came forward voluntarily and signed the deed. They all ran to lawyers, they all freaked out, they hid. We had to sue them. We had to file a lawsuit against the whole block to get them to clear this. Who asked about a quiet title action? That's what we had to file. Because the person that filed that deed had no right to this that he deeded. But he clouded my client's title. It could have been solved with a quitclaim deed, because all the quitclaim deed says is, whatever I have, I'm giving to you.
But in that case, it doesn't specifically state what is being given.
Yes, it does. Well, it's a blank. It's called a legal description. What they're specifically giving is my client's house back to them. Not warranting it, not saying they own it, but if they had any interest created by that wild deed, we're giving it back. That's all. That's all we're doing.
So what happened after the...
So we filed a lawsuit. One of the neighbors was a physician who hid behind the upstairs window. The process server saw him up there and wouldn't come and get served. After everybody got served and they ran to lawyers, I think everybody came and signed the deeds. Once their lawyers looked at what was really going on, no. We just have to get their attention better. I mean, it's just stupid. Actually wanted to, okay. Okay, so this is a special warranty deed. You can tell. You know why?
This says it?
There you go. Look at that. I love when people get the obvious ones, but I moved it up a little. It still says it there. It's a special warranty deed. For my New York friend over there. This is a bargain and sale deed with covenants against grantors' acts. I'm translating that to New York. Does the same thing. Some states give it different names. That happens to be New York has different words for things, okay?
What about the Florida?
Special warranty deed. This is Florida. My documents are Florida documents. I'm a Florida lawyer. That's just, and you're sitting in Florida. You want to learn about New York law?
Well, I meant like a description, you know. You gave him a New York description of what the...
Only because he's always got the New York examples, and I just wanted to know that there is a New York, it's the same legal principle with a slightly different, with a kind of a longer terminology.
I only lived here for 35 years.
I understand. My parents came from there. And my father was a lawyer then. So.
So Suffolk County, right?
What's that?
Suffolk County.
Not me. I know. I was born and raised here.
No.
Dade County. No, my parents lived, well, I don't know where they lived. They lived in Manhattan before they moved here.
Oh.
Okay, so, parts of the deed. I'm going to show you parts of the deed and I'm going to explain what some of it is. So at the very top, you have the grantor and the grantee. I've taken names out, obviously. The grantor is what you would think of as the seller, the one giving. And here's a little trick for you, because everybody gets confused by this. In every legal in sub-legal documents, where you have words that end in or and e, you have grantor, grantee, lessor, lessee, mortgagor, mortgagee, as opposed to easier words to use. Seller, buyer, tenant, landlord, lender, borrower, okay? The or is the person giving. The E is the person receiving. That's the easy way to remember it. So, up at the top, it's who the parties are. And you need their names and addresses. If there's entities, you're supposed to make it clear, say, you see where it says a Florida limited liability company after the name? As opposed to, it could be a liability company formed in another state, but you want to distinguish it. And you also have to have grantor and grantee addresses in Florida for the reporting purposes. Here, it talks about the consideration and the fact that it's conveying. You see $10. Some states require you to put the actual consideration in there. This is just a recitation of legal consideration. Obviously, it's not $10.
Isn't that the $10 was supposed to be just a recording fee, right? For
No.
recording the paper?
No. This $10 is legal consideration. By coincidence, the first page of recording is $10 at the moment in Florida. The first page. Each additional page is $8.50. $10 is the recitation of legal consideration, the value that the grantee is giving to the grantor in exchange for the property. You have to exchange value for value. But it says $10 and other good and valuable consideration to the grantor in hand paid, it's a little antiquated, by the grantee, the receipt whereof is hereby acknowledged. So the grantee and the grantor are exchanging things, and here the grantor is saying, I have received value. Well, today's world, it's the wire transfer for the purchase price. Then it says where it is, and then here you have the legal description. If it's a simple one, it would be typed right in the body. If it's more complex, and it can be a paragraph or a whole page, or the ones I've been doing lately, 3 and 4 pages, which is ridiculous. There. Now, the subject to provisions. You see those subject to provisions there list a whole bunch of things. Taxes is the one that always, listen to this is important. Taxes always has to be there, because you're always going to be conveying subject to taxes. It should be taxes for whatever is unpaid. So right now it's going to be, assuming the 2019 taxes were paid, you would convey some 2020 taxes. In October, you would have said 2019 taxes and subsequent years. In between, it depends on whether they're paid or not paid. Other standard things, that these words that you see here, no, these are not standard words here. Okay, zoning and/or restrictions and prohibitions imposed by governmental authority, that's standard. You can't get away from the zoning. Restrictions, encumbrances, mortgages, and other matters appearing on the plat and common to the subdivision, and utility easements of record. That's a red herring, guys. That's a bad deed. You would not want to accept this deed. You would never want to have encumbrances and mortgages on there. Because now and I'll tell you why. Anything in this subject to paragraph is taking away from the warranties of title. What, pray tell, you might ask, are the warranties of title? And that takes us down to this paragraph here. And you can read them. The grantor covenants with the grantee that they are lawfully seized of the land in fee simple. That means they own it. That they have the good, right, and lawful authority to sell and convey said land. No, there's nothing preventing them from doing that. They're making a warranty and a representation that they have this right. That they specially warrant the title, which means they're saying that it's good, but the specially is important. By, through, and under the grantor and no others. That's what makes it a special warranty deed. And I'll distinguish that from a warranty deed in a minute. And will defend the same, is that fuzzy? Look at the screen. Defend the same against the lawful claims of all persons arising by, through, or under the grantor and no others. So, the feature of a special warranty deed is your warranty title to what you as the seller have done to the title, not what's happened before you. We're going to compare that to a statutory warranty deed, hopefully. Because the statutory warranty...
What the seller has done to the deed?
To the title.
To the title.
Okay? You see at the top, right, this is a statutory warranty deed. Oh, here you'll see some more examples in here now. See, I left some of this in, but I redacted information. I left a typical condominium legal description so you can see what they look like if you're unfamiliar. Now, this must have been an estate planning deed I did, because what happens is they tell me they want to move it from grandpa to grandpa's trust, but they're not asking me to do a title search. So we put this in here. This NB, paragraph NB is Latin, nota bene, which means look here. And it's there to protect me from, because I didn't examine the title and I haven't looked at it, and I'm not telling them that it's good, I'm just doing the transfer for them. The same subject to, except this one's okay, covenants, easements and restrictions of record, matters of the plat, existing zoning and taxes. But this is the distinguishing paragraph. Grantor does fully warrant title to the land and will defend the same against the lawful claims of all persons whomsoever. What that means is that they're warranting that they have good title, that they received good title, and that they're passing good title forward. Legally, it means that if there's a problem that you have to sue them, you can go back up the chain to clear things up. And that has an effect both legally if you do a lawsuit and also to go back and go after title insurance back up the chain.
So basically they will defend any claims, I guess.
Any claims whatsoever. Now here it says fully warrant. That's statutory. The warranties were actually laid out one at a time in the special warranty deed. Those several sentences, and I'm going to make sure if this is not posted where you can actually see them, I will make sure that they are. But those specific words that I gave you, that I showed you in the special warranty deed, are the warranties of title. When you say fully warrant under the statutory, it incorporates those in here, so they're included.
Would it have been a safer bet to do the title search and let the title company be responsible for any issues with title rather than the grantor, which is people, guaranteeing this deed?
Well, very often you will have title insurance with it, but you require this as well, because otherwise you can't go back against the seller's title insurance if you don't have a warranty deed.
Yeah, but the new buyers, which I'm assuming...
This is not a purchase.
No.
This is not a purchase. I said the reason for this, the reason for the NB was that Grandpa's conveying it to the trust. Okay, so so there's no purchase, so they don't want to spend, don't have a title examined.
Okay.
We're just transferring it into the trust for estate planning purposes. But because of the warranty deed, if the trustee or the heirs have a problem with the title, they can now go back after Grandpa's title insurance because of the warranties of title. Even though Grandpa has conveyed it to the trust, we can now go back because of the warranties and make a claim on his title insurance if there's a problem back up the chain.
And there's no way the title company could conceivably back out and not defend the title when it is transferred, because given it is now transferred, so
If it were a quitclaim deed, so that you didn't have those warranties, then yes, then they don't have an obligation, the title insurance goes away. The title insurance technically goes away, except it's protecting grandpa's interest from the time he owned it, and if there was something wrong, and you're suing him, or suing his estate, because of a breach of the warranties of title, then his title insurance has to defend.
So it seems that the warranty deed favors the prior warranty, right? Is that?
Well, it's better. It's better. It's a better quality of deed. Yes.
And so I have just a quick question for clarification.
Sure.
So the special warranty deed, you were saying that, so what the seller has done to the title, but the warranty.
Seller only.
Right.
By, through, and under the grantor.
Right, but in the warranty deed, you can go
Back.
further. Okay.
Back. I don't have an example because it's not really necessary, but a trustee or a personal representative really does not have authority as a trustee or as a personal representative to give warranties. So a pure trustee's deed or personal representative's deed would read like a quitclaim deed. It wouldn't have any warranties of title. It would just say that I am the trustee, I'm duly acting, I'm authorized, blah, blah, blah. But a lot of people balk at those, so you can get the trustee to give a special warranty deed which says that the trustee hasn't done anything to damage the title and their warranty of their title. Even more importantly, where it's a grantor trust, if it's a grantor trust, like, let's say Grandpa's put it in here into his trust, in this deed. And now, a year from now, he goes to sell it out of the trust. Because you're going to require it to come out individually in trustee, because it's a revocable trust, it's Homestead, all those good things. There, he could warrant the title because he was the owner. And effectively, he's conveying out individually and as trustee, so that would be the exception. Otherwise, in a representative capacity, a trustee or a personal representative should not warrant the title.
this is all under statutory deeds, right?
These are on the different kinds of deeds, on the warranty deed versus special warranty deed. Now I have to figure out how to get back to. Bear with me a second.
Click on that bottom one there.
Thank you. Thank you, tech support. Oh, good, okay. So now I want to get a little more into the subject twos. The subject to wording is the stuff that I told you where I was surprised a little bit to see and objected to the fact that it had mortgages and other encumbrances. Anything in the subject to paragraph, and people are so casual about this in general practice, especially when you're dealing with title companies, because title company people just do what, they just repeat things by rote, and they are not skilled in real estate transactions like real estate lawyers would be. So they're just going to put whatever they want in there. They're going to say things like subject to conditions, restrictions, and limitations of record. Those are bad words, and I'll tell you the reason. Restrictions might say you can't have alcohol, or they might just, you never know what it might say. You can't have a dog on the property because the owner was anti-dog. A limitation might say something like this property can only be used for the next 20 years as commercial, and then it has to be vacant. Some silliness like that. But the most dangerous word is a condition. A condition, I have an example that I wanted to share. Okay. A condition would say something like, my example, the person's name is Kelly. Kelly owns some real estate, which is conveyed to her from her father with the restriction to Kelly unless the property is used for commercial purposes. So, if Kelly uses the property for commercial purposes, there's a condition, and her father could reclaim the property. So a condition could result in the person losing the property if they breach the condition. That's title being vested subject to a condition. That's a weakness in title and a dangerous one. So you never want the word conditions in that subject to. Subject to clauses take away from those warranties. So I'm making warranties, whether I'm warranting my title or I'm warranting everybody's title, I'm not warranting anything that's in that subject to provision. Okay? It's like accept. A reference to a purchase money mortgage. Now, remember we talked a little bit about a purchase money mortgage back to the seller. Purchase money mortgage back to the seller is recorded, but it should be in the subject to language in the deed. Because if for whatever reason the title companies don't catch the mortgage in doing an examination, by seeing that reference in the deed protects the person holding the mortgage because there's a recorded reference to the mortgage. Always should be subject to easements and rights of way. Dedication versus a grant. That's we're talking about rights of way in this case. A dedication would be the situation where we're going to create a public road, and we dedicate this road down this middle here for the use of the lots. It is possible at some time in the future, or the dedication could have taken place in the past, it's possible that this road will no longer be in use. And all of these houses have been removed, and the developer now wants to use this entire property here for commercial purposes. Instead of it being 40 houses, now we're going to make it a Walmart shopping center. So they buy all the property, they buy each individual platted lot. And now they file a proceeding to vacate the plat. The vacating of the plat makes the dedication of the road go away, and then the road becomes owned by the property owners on either side to the center line. Okay? In this case, they own the whole parcel, so they're going to own both sides, so they own the whole thing. A grant, as opposed to a dedication, is what you'll see when there's a road right-of-way, a road widening, like they're going to expand the turnpike, and you'll actually see a deed from the property owner to the state of Florida, Department of Transportation. That does not get affected. You'd have to get a deed back to get that back. That's a dedication versus a grant. Conditional versus permanent, don't worry about that. An easement by way of necessity is an easement that you can acquire because you can't get to the property any other way, and because the seller sold you the piece of property. For example, we have a situation, my example where the owner of the seat in the corner bought the property from the guy that owned the rest of the block. But there was no road there. He has to have a way out. So he can get an easement by necessity to cross over the land to get out from that back corner out to the public road. Talked about examining title. History. Why did I put that in there? You know, just to talk about, so I didn't bring the abstract to show, but it's great. And I may have mentioned this when I was doing the overview of the first week. When you look through the title and you see who owned the various parcels, you know, the history's great because you see names. I think I told you there was a guy from Colorado that came and bought huge amounts of land in southwest Broward County. His name was R.P. Davey. So, you know.
I don't remember their names, but I know Doral in Miami, the people that own the property, her name was Doris and his name was Al.
That's correct.
Yeah.
Last name was Caskel.
Okay.
They also own a hotel on Miami Beach.
Yeah.
Yes.
And Henry Flagler, of course. And, yeah.
Plenty.
Yeah.
I mean, anybody live in the northwest part of Broward County? They know where Lyons Road is?
Yeah.
Lena Lyons owned a whole bunch, she was a woman that owned a whole bunch of property up in that part. All these names and roads, they all had humans involved at one point in time, and you see that. You look at I have an old tax map of Broward County that's got who owned the property, I think it was from 1959. And you look at the names and you'll see names, famous names that you know. There was a guy that owned a bunch of property in Plantation, his name was Peters. You see Peters Road, Plantation? It's everywhere like that. Anyway, that's...
Campbell Boulevard.
What's that?
Campbell Boulevard.
Same thing.
My family lived on and I used to want it, so I heard.
So, there was a governor of the state of Florida back in early part of the 20th century, and his name was Napoleon Bonaparte Broward. Broward. Napoleon Bonaparte Broward. And he created the drainage system that drained the Everglades and put the canals in so that what was all swamp became usable land. You had Dade County and Palm Beach County, and they touched. And sometime around, I would say 1917 approximately, the legislature decided it was time to create a new county, and subdivide a new county out of the northernmost part of Dade and the southernmost part of Palm Beach County, and they named it after Governor Broward. To this day, if you're examining title, you will see plats and things in areas in parts of Broward County, in the south end, old stuff, even right around Fort Lauderdale, the plat called Progresso. It's just north of downtown, south of Sunrise Boulevard, and you will see that you look at it, the plat was recorded in the public records of Dade County, and you'll see the phrase in the legal description, said land lying, situated, and being in Broward County.
If someone was to go doing a title examination from that era, they wouldn't actually find physical paper to look at today. They'd have to find, what do they find that goes back that far?
If you have an abstract of title, you will see physical pieces of paper, but what happened was as time went by, they summarized them in a typed paragraph in the abstract. So instead of seeing the photocopy, because I actually have deeds that a client had given to me, a client who was a surveyor, and at one time he owned the oldest surveying company in Dade County. The surveying company that actually created the plat of the city of Miami in the 1890s. And he gave me some deeds from that era, and they are handwritten, they have tax stamps on them, and back then you would actually get an abstract with copies of those original deeds. But as it got further back in time, instead of having to duplicate the copies that really didn't have a whole lot of meaning, it was just a paragraph that described the deed, or a typed version of it, just because it took up less space and it was easier to reproduce. The gap. I'm not sure that's what I meant in this part of the outline, but let me talk about the gap in examining title. So there's title evidence, even with computers. The abstracting plants and the title underwriters that create the title commitment, they can only get information up to a certain amount of time. There's always going to be some time between that last evidence of title and the closing date. It can be as much as 2 weeks. It can be 7 days. It depends upon how busy they are. Right now, the activity is such that it's probably running about 2 weeks. And so this is called the gap. It's a period that you don't have information. And so one of the closing documents is an affidavit from the seller, and in that affidavit is a statement that says that there's nothing pending against them, and they haven't conveyed to anybody else. And they haven't done anything to the title during that period of time. And they're doing it for the purpose of the buyer relying and for the title insurance company to rely on it.
So the gap is
the time between
the last available evidence of title and the recording of the deed and the closing.
okay. So it's not like some gap in history from
No.
1920 to 1940 or something.
No.
Okay.
Because that you can get around with the Marketable Record Title Act.
But it's only a phone call to the title company to give them ask for a continuation from then till now.
They don't have the data. They don't have the data because there's a period of time that their data only goes up to. So when you get the title company, for either it's a phone call or a computer printout or anything, there is still, right now, about a 2-week time period. If I were to go on the computer and do a takedown for closing, there's a 2-week gap between their most current information that they have available to them and the time you get that deed in the public records. You can't fix it, except by affidavits. And you can insure it without showing you the actual copy of the title commitment. That is an exception that you always have deleted, so that the title underwriter ensures that time period with the right documentation. Other title issues, we talked about encumbrances. Those are mortgages typically, they could be old mortgages, they could be things that are unsatisfied, they'll be covered by title insurance, or you have to deal with them in one way or another. A cloud on title is something like the deed I described, where it was a deed that was executed with an improper legal description so that it messed up the client's corner. That's a cloud on title. Restrictions. A lot of property, especially residential property, has declarations of covenants and restrictions that tells you what you can and cannot do on the property. It's by contract. You can't make it go away. It's for the benefit of everybody that's living there because you don't want a factory next to your house. A lot of restrictions are handled by zoning, but in terms of private restrictions that a developer puts on there, or in a declaration of condominium. Reservations, usually you'll get coming into the state of Florida. So the state of Florida collects taxes. Back in the 30s and 40s, the economy got bad, people weren't paying their taxes, property went back to the state for the unpaid taxes, and then when the state conveyed the property out again in the 40s, they did something called Murphy Act deeds. And in those deeds, there was a paragraph that said that the state saved and reserved a strip of land 50 feet wide or 100 feet wide on either side of the center line of any state road that existed for the purpose of widening the road. Now, maybe they did widen it, maybe they didn't widen it, but what happens is when you're doing a current examination and you see this, well, maybe the road is in place, but your property's here. And that line comes to here, which is a third or a quarter of your property. So you have to go, if that's still a valid restriction, you have to either find out that you're going to get the road widened into your property and be prepared for it and doing the redevelopment, or you go to the state and you can apply to have it released. And it depends on what their real plans are, but that's a title problem. That's a reservation held back. The other reservation that was very common in the Murphy Act deeds that they will not release, and in fact I think in some parts of the state they will still retain it, is a reservation for oil and minerals, where the state reserves the right to 3/4 of all revenue from oil and minerals that you mine on a given property. Now, obviously if you're talking about developed land, you're not going to do any mining. But back in those days when it was rural land and upstate land where there were these things, they reserved the right to some of it. It's not a problem. The problem is something called the right of entry and exploration, which comes with those reservations. And that's the right to actually go onto the property and dig. Dig for phosphate, drill for oil, things like that. There is a statutory release that if the property is, I think it's 20 acres or less, or 5 acres, I forget what the number is, it's released automatically as to that. Once the tract is small enough, it's released by, the right of entry and exploration is released. But if you decide to drill for oil in your backyard and that reservation is there, first of all, you're probably violating your covenants, but if you hit oil, you have to share with the state of Florida, because that was the deal when they gave you the land.
Can you just repeat what you said about reservations? It's a condition or a demand by the state for...
It's reserved in the deed. The state says, I'm giving you the land, just like grandma kept the life estate, I'm keeping a right to 3/4 of the minerals. The state is keeping a right to 3/4 of the minerals or oil that you mine on this property. It's a reserved right, a reservation. Something I'm keeping back from what I'm giving to you.
Like the widening of the road.
That's a different kind of reservation. The third kind of reservation that you used to see was a canal reservation. Goes back to the drainage situation, where they reserved, I think it was 130 feet on the center line of a section, I think it was, for the construction of canals and for spillways, whatever, there's all kinds of stupid words you don't see anymore, sluiceways, areas to be able to go on and dredge and keep the canal clean to maintain the canal. Because canals are important when you live in the swamp. You have to do something with the water. I mean, our canal system, especially here in South Florida, you just drive by them and don't think about it. But when we have huge amounts of rain, they have to open the gates to let the water rush out to the ocean. And if we're going to have a hurricane, a wet hurricane coming, they have to lower it. But if the hurricane doesn't hit, then they have a problem because now they've released water reserves. So it's a delicate, that's why you have something called the South Florida Water Management District and the Central Broward Drainage District. And these are governmental entities that deal with those things. That was a bug. Warranties. Sorry, I know this is not the most fascinating topic. I have to make up for loosening up on the other loan documents. I know that this